Good morning. Here I am ordering groceries because it's Friday. Got to order some groceries for these folks and completely lost track of time, y'all. But today we are tapping into Karina Cooper. We are going to get some rebuttal from the defense, maybe a little rebuttal from the state, and then we are moving into the jury charges. I'm sorry, the jury instructions and closing arguments. So I don't know if the jury really gonna get time to deliberate, or if they're gonna have to spend some time over the weekend just thinking about the case but not talking about it. But we shall see how the day turns out. One thing I am working on right now is the Faith Evans lawsuit. I don't know if y'all heard about it, but Faith Evans is being sued by the estate of Biggie, saying that she isn't allocating the money appropriately. They say that she has not been in communication with the estate this entire time, and said that she may be pocketing some of the money and distributing it to some of the children and not to the estate itself. So I am looking for that lawsuit to get us some content out there. It's about time we drop something because I didn't think I really pushed nothing yesterday. We just did a little live, but we didn't produce any content. So I'm going to be working on that while we listen to Karina today. I never heard of the defense getting a rebuttal. Yes, they're getting a sir rebuttal, as it is mentioned on the screen. I mean, at the end of the day, they were going back and forth yesterday arguing about how she texted him. She's saying that she sent him 3 messages saying go to bed. But the forensic person, or let's just call her the expert, said that she only seen one message that was like go. Um, so we shall see. And there was just like a lot of back and forth around if the messages were deleted, if they could have been recovered, etc. So I'm not sure how much more the defense is going to hit on this dead horse, but the horse is gone. It's left the stable. It done passed out from exhaustion in the field, and it's over with. It's over with. So, like I said, very interested in hearing what else they have to say today. Let me see. I haven't seen any other interesting interesting headlines that I think we should have some content on. Everybody is talking about how Melly decided to go against the y'all, Miss Donna got a hearing today as well. We might pop into Donna's hearing. Good morning, Tippy. We might pop into Donna's hearing because Donna got her a little hearing today. If you don't remember, Donna is the mother of the woman who had her who allegedly had her family unalive her husband after a nasty divorce. She wanted to go back home and take the kids with her. The husband was a lawyer. He was a professor at the university. He was granted custody of the kids, and he ended up unalived. And he ended up killed, y'all. So the brother has been charged and tried and found guilty. And now the mother is up. It's her turn. So I know I'm going to miss Donna's trial. So y'all going to have to make sure y'all keep me up to speed on her. Yeah, keep me up to speed because I'm definitely going to miss it. We also have like this summer lawyering fundamentals course that we have to do online. That actually starts next week. So I'm doing a lot of my pre-work for that. It's an online course, but it's basically supposed to teach us strategies to be successful in law school. So I'm about to go over what case briefing is, outlining how they're expecting us to write essays. And apparently I'm about to get some of my torts class material. So I'm a little excited. It's like this thing is becoming more real every single day. Oh, Taylor Gang, I don't know if I shared it with y'all. I know I've shared it on other platforms, but I do have a law school registry. If you want to support my journey, if you want to help me get some of the stuff that I got to get in order to start school. Now, y'all, let me tell y'all how I was out here pricing these books, trying to figure out how I'm going to get these books for the cheap. And I didn't log into the school's team account. And they didn't told us, like, yeah, they are announcing a partnership with the bookstore to make our course materials more affordable. So instead of like a traditional purchase, the school is going to charge a book fee of like $26 per credit hour that will pay for our books. So I am like thrilled that the books are a lot less expensive than I was like anticipating. So now for like my torts class, the book would have been $236, but now it's only going to be a book fee of $78. So I took my my books that I was trying to get, I took it off my registry. If you know, my registry really started off as me gathering a list of things that I wanted to get for myself because I'm that person, y'all. When I had Marley, I created a whole registry and bought everything off of it. Like that's just me. I never sit around and wait on people to help me or to do anything. So I kind of started doing the same thing with law school. So I just created a registry and started throwing stuff on it that I wanted to get for myself. And somebody convinced me to share it. So I'm sharing it. If you want to, you know, you're welcome to purchase anything off of it. It's greatly appreciated, but it's not mandatory. Like for the things that are going to get bought. Okay. But I'm going to share it with you all so that you all can see it, so you can see what's on it, see what I got on there. A lot of, like I said, a lot of things has been purchased off of it, but I didn't really go crazy, right? So I'm gonna share that here with y'all in just a second whenever I get that thing up. Good morning, D Wood. Good morning, Kim. Um, Tippy in the building. I'm trying to think what else, y'all, on this beautiful Friday. I'm so excited too, y'all. Like, we about to be real. I'm really about to be in class, making videos and posting it out here on YouTube because I'm gonna be telling y'all about how a day in my life go. Day in a life in college and trying to be somebody mama and still trying to work a job. Don't tell nobody though. Don't tell nobody though. Because they say you're not supposed to work. But my job was like, we will work with you. Don't leave. Don't leave. And I'm just like, y'all. All right. But I'm telling y'all right now, what's gonna come first. And you know, push come to shove, y'all get the trip, and I'm gonna be like, all right, I'm out. I didn't already let them know. So however they choose to proceed is on them. It is literally on them. All right, let me see. What else do we got? No, we just waiting on Miss Karina to get it popping. Thank you, Tracy. Or Treese, I'm sorry. she said you said it right. Coming from the bushes, okay, because it'd be so hard. Now, when somebody tell me their name, like they say it out loud, like I never forget it. Never forget. I'm like, okay, this is it. But I will say our schedule is still missing two classes. We don't have our legal writing class, nor do we have our legal research class. And so apparently the class is it's the largest. Good morning, B. It's the largest incoming class the school has seen in a few years. Like I said, the law cycle was crazy. It was crazy. And so um they have to like make some more sections of those two classes because they were not anticipating this large of a turnout. But yeah, I'm ready. I'm ready. So this week, y'all, let me tell y'all what we're working on this week. Well, I got to do pre-course stuff. So, of course, I got the syllabus because, yeah, got to read that. I got to read navigating your course document, the outcomes. I have to download, save, or print the torts case materials. And then I have to complete the discussion board by introducing myself. So that's what I have to do to start. And then for days, because this thing is running from the 15th until August the 2nd, which is just a couple weeks before school start, actually. But the first thing that we're going to do is the introduction to the course, lawyering and the legal system. So we're going to be reading the 4 anchoring principles of lawyering fundamentals. I'm going to have to complete an introduction to the lawyering lecture, parts 1 and 2. I'm also going to have to complete an introduction to legal system lecture. They told us to, and then I also have a discussion board post. What's so interesting is that they told us like, I'm going to be dedicating 3 hours of my time to this class every day from now until the start. So I'm just like, I'm kind of like, what's a good way of putting it? I don't want to say I'm in awe because I'm not in awe. I'm just like, I don't know. I'm I'm a good nervous anxious to start if that's a good way of saying it. Like I'm just like, oh my God, it's surreal. It's like it's happening. Like this is a real thing. This is a real thing. I don't know, yeah. I'm rambling right now. Since I didn't logged into this thing, I don't know what to do. But yeah, I plan on knocking out my pre-course work today. My son then lost my Apple Pencil. I gotta go find that. Cause I need that joint. Okay, my little phone just keep falling, so we just gonna move it on over to the side. Here we go.
All right, good morning, everyone. Go ahead and have a seat. All right, we are back on the record with our jurors present, counsel and parties present, also with a little noise from the construction outside present. So bear with us. And it's my understanding that at this point the defense has an additional witness to call. Is that correct, Ms. Watt?
Yes, Your Honor.
All right, you may call your witness.
All right, the defense calls Chris Lyon.
Good morning, Mr. Lyons. Just come on up and have a seat to my far left, if you would. And turn on that microphone if you can there at the bottom and adjust it however you'd like. There you go, sir. I'm going to go ahead and swear you in. If you please raise your right hand. Mr. Lyons, do you swear or affirm, sir, that the testimony you'll be giving in these proceedings will be the truth?
I do.
And for the record, sir, can you please provide us with both your first and last names and spell them?
Christopher, Kristofer, Lyon, Lyon.
Ms. Watt, whenever you're ready.
Thank you. Mr. Lyon, how are you employed?
I work as an investigator for the Public Defender's Office, and I'm also a digital forensics examiner for a consulting firm.
Can you tell me about your training and experience that gives you the ability to do the digital forensic analysis?
Sure. I started out with kind of the proprietary training, like with the companies that make software for digital forensics. So I have some training from Cellebrite, was one of the main players. And then I have some what they call vendor neutral training, just like international organizations that teach on digital forensics, but aren't specific to a brand.
I didn't hear what was the last part that you just said?
And then I have training from like international organizations like IACIS that's vendor neutral.
And how long have you been doing this forensic analysis?
Hold on a second. Can you folks hear? All right. You can hear. Yeah, I should be clear what I'm asking. What you can hear. Yes. Can you hear the witness? All right. I'm going to ask that everybody sit tight. I'm going to go see if there's something I can do about this. There's no guarantees, but I will try. Feel free to stand, stretch. I'm just going to remind you of that admonition I've given you previously, but don't leave.
FER.
I didn't know that was construction. I thought it was the fan. Oh, child, that is messy and disturbing. I'm like, what they doing? Cutting the walls out the courthouse? What's going on over there? Do what? I don't know. If he said it, it didn't went over my head.
Years.
What law enforcement agency did you work for?
I worked for two. Most of the time was University Heights Police Department, and then briefly for West Liberty Police Department.
Did you review phone data in this case?
Yes.
What did you all review? Did you review, I'll just shorten it, did you review Karina's iPhone 8?
Not in its entirety, but some of it.
Okay. What software did you use to review the phone?
Magnet, Axiom, the kind of the portable version, not the full paid program.
Essentially, did you review what we were able to provide to you?
Yes.
How many, do you have a guess as to how many phones or information from phones you have reviewed in your career?
I don't keep a tally, probably 100 more now.
Okay. Have you ever, in reviewing phones, have you had any, seen or noticed any signs of data loss?
Yes.
Tell us what data loss is.
So I guess it depends in what context we're talking. Mobile devices, we like to think we can download them and just get everything exactly as they are, everything on the phone. But to download devices, they're essentially hacks. Someone at some point kind of had to figure out a flaw in the phone to be able to hack into iPhones and download the data. So these companies use exploits or these kind of hacks to gain access to a phone. Apple doesn't tell these providers, these vendors, how to access all the data on the phone. So we kind of have to figure it out, and it's not a perfect science.
Okay. Is it the same case with Snapchat then?
Downloading Snapchat from the phone?
Yes.
Yeah, anything on the phone is, yeah,
Okay.
same thing applies.
So is it fair to say that we don't know exactly how we have some Snapchat information on a phone, but not all of it?
Right, there could be a lot of different reasons. Data in general could be missing. It might have been on the phone, but the software like Celebrate wasn't able to pull everything precisely as it was on the phone. Databases on phones, just the method for storing information clears things out when they're removed. It does things for space saving. It optimizes memory, so things kind of move around a lot.
So, may I approach, Your Honor?
You may.
Showing you first what we've marked as Defense Exhibit L. Do you recognize this?
Yes,
What is that?
that's my CV.
So is this basically kind of like a resume or all the jobs you've held?
Right, resume of jobs and training.
Your Honor, at this time I'd ask to enter into evidence what we marked as Defense Exhibit L.
Any objection?
No objection.
Defendant's Exhibit L is admitted.
Then next I'm showing you what we've marked as Defendant's Exhibit K. Do you recognize this?
Yeah, it's a screenshot of that magnet Axiom program we were talking about earlier.
And does this screenshot display data from Karina's Snapchat on here?
Yes.
Your Honor, I'd ask to enter into evidence what marked as Defendant's Exhibit K.
Any objection to K?
No.
Defendant's Exhibit K is admitted.
And permission to publish K, please?
You may. Are we, which,
This one.
okay.
Okay, so on Defendant's Exhibit K, what we're looking at, this is the software that we use to explore the phone, right?
Right.
And so this is a screen capture from what would be shown if we look at the Snapchat messages that were remaining housed on Karina's phone.
Yes. Yeah.
Okay. Because it says here that there are 2,409 messages, right?
Right.
And And we've got some highlighted. Showing you Defendant's Exhibit B.
So starting here in the middle, do what we see on the screen, the content of those messages, does it match these?
Yes, it looks like it.
And maybe I missed, I just want to be clear for the record. What you showed him was the Defendant's Exhibit B?
Yes.
All right.
Okay. So then these being the messages retrieved between Houston Danker and Karina Cooper from the early morning of June 18th. What I want to know is what are those numbers in the middle?
So the column is kind of cut off, but that looks to be the message ID. It's kind of just an integer, a number assigned to messages in a database.
And does Snapchat assign message numbers to each message?
Yeah, the software does.
Okay. And so here we see numbers going, they're going in sequential order, right?
Mostly.
At least the ones that I have highlighted.
Looks like the one at the very bottom
Right.
isn't, but all the others are.
Okay, so the one at the very bottom, go, that is number 33897, and then the next message is 33984.
Yes,
Could that be data loss?
it certainly could be. In digital forensics, we like to test everything to understand how the software works. You know, there's no manual that says what this message ID is. But in general, with this kind of data, I would expect that to mean something's missing. And if I can just add, I haven't tested this. So normally I would like to test and be able to understand the mechanism. But in general, in databases, that would indicate something's not there.
I do not have any other questions, thank you.
Mr. Kodiaga, any questions?
Yes, and if you can just keep that up, Your Honor.
Okay.
Thank you. You just said you've not tested this, correct?
Correct.
So what you're testifying to this jury is something that you have not tested, you have no idea what it means, correct?
I wouldn't say I have no idea. I can understand the general principle of how it works in databases, but I haven't tested it for Snapchat.
You don't understand the mechanism, do you?
I understand the general principle of how databases work, taken training on that. But again, I don't know, I don't work for Snapchat, I haven't tested this precise mechanism.
Do you know that when sufficient time passes at Snapchat, the numbers keep adding up? So if a minute passes, the numbers will add up if there's no message at that point.
That could be true. I don't know it to be true.
Okay. And and as you said, you talked about data loss earlier on. Does data loss happen sometimes because someone deletes incriminating evidence?
Of course.
I have no further questions for this witness.
Anything further, Ms. Watt?
No, thank you.
All right, thank you, Mr. Lyon. You may step down. Ms. Watt, any further rebuttal from the defendant?
No, Your Honor.
Any further witnesses for the state?
No, Your Honor, the state rests.
All right. So now we're back to where I told you I thought we were at some point yesterday. What we're going to do at this point, ladies and gentlemen, is we're going to go straight to me reading you the jury instructions, or at least most of the jury instructions. Aaron, if you'd want to pass out, we're going to provide you each with your own individual copy of the jury instructions so you can follow through as I'm reading them. While she's passing those out, counsel, I just wanted to ask real quick, we made a record on jury instructions before We finished all the evidence. I don't believe anything has changed, but I just want to confirm that neither party needs any additional record related to jury instructions. Mr. Kodiaga, any additional record from the state?
No, Your Honor.
Any additional record from the defendant, Ms. Watt?
No, Your Honor.
All right. So, ladies and gentlemen, the other thing you'll notice is that once I start reading these jury instructions, Colleen here is going to stop typing. That's not because they're not important. It's because we already have a record of what's being said. It's here in print, so I'm going to read these. She doesn't need to type essentially what I'm reading. So that explains that. Just want to let you know so you didn't think there was any significance to that. So with that, ladies and gentlemen, I'm going to start with the jury instructions. Members of the jury, put on my glasses. The trial information in this case accuses the defendant of the crime of murder in the first degree in violation of Iowa Code Sections 707.1 and 707.2, Parent 1. Included within the charge of murder in the first degree are the lesser and included offenses of murder in the second degree and involuntary manslaughter. To these charges, the defendant has entered a plea of not guilty. Upon the issues thus made, you're instructed as follows. Instruction number 1. The trial information is the document that formally charges Karina Cooper with a crime and is merely the method by which she is brought into court for trial. It is not evidence. Instruction number 2. Karina Cooper is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of Ms. Cooper. The presumption of innocence remains with Ms. Cooper throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. Instruction number 3. Karina Cooper has entered a plea of not guilty. The plea of not guilty is a complete denial of the charge and places the burden on the state to prove guilt beyond a reasonable doubt. And just an update on the noise, I was informed they need approximately 10-15 minutes and then they're done. I'm going to keep going with this while we're doing that. All right. The plea of not guilty is a complete denial of the charge and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you, the state must prove something. It must be by evidence beyond a reasonable doubt. If the state does not prove Karina Cooper guilty beyond a reasonable doubt, your verdict must be not guilty. Instruction number 4. The burden is on the state to prove Karina Cooper guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence or lack of evidence produced by the state. A reasonable doubt is a doubt based upon reason and common sense, and not the mere possibility of innocence. Proof beyond a reasonable doubt does not mean proof beyond all doubt. If, after a full and fair consideration of all the evidence, you are firmly convinced of defendant's guilt, then you have no reasonable doubt and you should find defendant guilty. But if after a full and fair consideration of all the evidence or lack of evidence produced by the state, you are not firmly convinced of defendant's guilt, then you have a reasonable doubt and you should find defendant not guilty. Instruction number 5. If there is a reasonable doubt as to the degree of the crime, Karina Cooper shall only be convicted of the degree for which there is no reasonable doubt. Instruction number 6. You shall base your verdict only upon the evidence and these instructions. Evidence is testimony in person or by deposition. 2, exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. 3, stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to, which were not offered and received into evidence, are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers, objections and rulings on objections, any testimony I told you to disregard, anything that I tell you as part of these instructions is not evidence, and lastly, anything you saw or heard about this case outside the courtroom. Instruction number 7. In considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Instruction number 8. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. It is your duty to determine the credibility of witnesses, to resolve any conflicts in the evidence, and to draw reasonable inferences from the evidence. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, 1, whether the testimony is reasonable and consistent with other evidence you believe. 2, whether a witness has made inconsistent statements. 3, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts. 4, the witness's interest in the trial, their motive, candor, bias, and prejudice. Instruction number 9. You have heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. Instruction number 10. Evidence has been offered to show that Karina Cooper made statements at an earlier time and place. If you find any of the statements were made by the defendant, then you may consider them as part of the evidence. Statements and questions by law enforcement during interviews of Karina Cooper are not evidence and may only be considered by you as context for Ms. Cooper's answers. You may also use the statements to help you decide if you believe Karina Cooper. You may disregard all or any part of her testimony if you find the statements were made and were inconsistent with her testimony given at trial, but you are not required to do so. Do not disregard Karina Cooper's testimony if other evidence supports it or if you believe it for any other reason. Instruction number 11. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that the person knows the act is against the law, it is necessary that the person was aware he was doing the act and he did it voluntarily, not by mistake or accident. You may, but are not required to conclude a person intends the natural results of his acts. Instruction number 12. The state must prove all of the following elements of the crime of murder in the first degree. 1, on or about June 18, 2021, Karina Cooper shot Ryan Cooper or aided and abetted Houston Danker in shooting Ryan Cooper. 2, Ryan Cooper died as a result of being shot. 3, Karina Cooper individually or Houston Danker aided and abetted by Karina Cooper acted with malice aforethought. 4, Karina Cooper individually or Houston Danker aided and abetted by Karina Cooper acted willfully, deliberately, premeditatedly, and with the specific intent to kill Ryan Cooper. If the state has proved all these elements, Karina Cooper is guilty of murder in the first degree. But if you find the state has failed to prove one or more of the elements, then you shall find Karina Cooper not guilty of murder in the first degree and proceed to determine whether Karina Cooper is guilty of murder in the second degree as defined in instruction number 13. Instruction number 13. The state must prove all of the following elements of the crime of murder in the second degree. 1, on or about June 18, 2021, Karina Cooper shot Ryan Cooper or aided and abetted Houston Danker in shooting Ryan Cooper. 2, Ryan Cooper died as a result of being shot. 3, Karina Cooper individually or Houston Danker aided and abetted by Karina Cooper acted with malice aforethought. If the state has proved all of these numbered elements, Karina Cooper is guilty of murder in the second degree. But if you find the state has failed to prove one or more of the elements, then you shall find Karina Cooper not guilty of murder in the second degree and proceed to determine whether Karina Cooper is guilty of involuntary manslaughter as defined in instruction number 15. Instruction number 14. Murder in the second degree does not require a specific intent to kill another person. Instruction number 15. The state must prove all of the following elements of involuntary manslaughter. On or about June 18, 2021, Karina Cooper shot Ryan Cooper or aided and abetted Houston Danker in recklessly shooting Ryan Cooper. 2, Ryan Cooper individually or by knowingly aiding and abetting Houston Danker did the act in a manner likely to cause death or serious injury. 3, by doing the act, Karina Cooper individually or by knowingly aiding and abetting Houston Danker caused the death of Ryan Cooper. If the state has proved all of the elements, Karina Cooper is guilty of involuntary manslaughter. If the state has failed to prove any one of the elements, Karina Cooper is not guilty of involuntary manslaughter, and you shall find her not guilty. Instruction number 16, as used in instruction number 12, willful means intentional or by fixed design or purpose and not accidental. Deliberate means after having deliberated, which is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Deliberation and premeditation need not exist for any particular length of time before the act. Instruction number 17. Malice is used in instructions numbers 12 and 13 is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. Instruction number 18. Malice aforethought may be inferred from the use of a dangerous weapon. Instruction number 19. Serious injury is used in instruction 15 as a condition which cripples, incapacitates, weakens, or destroys a person's normal mental functions and/or bodily injury which creates a substantial risk of death, or which causes serious permanent disfigurement or extended loss or impairment of the function of any bodily part or organ. Serious injury includes but is not limited to skull fractures and rib fractures. Substantial risk of death, as used in instruction 15, means more than just any risk of death, but does not mean death is likely. If there is a real hazard or danger of death, substantial risk of death is established. Instruction number 20. A person is reckless or acts recklessly, as used in instruction 15, when he or she willfully disregards the safety of persons or property. It is more than a lack of reasonable care which may cause unintentional injury. Recklessness is conduct which is consciously done with willful disregard of the consequences. For recklessness to exist, the act must be highly dangerous. In addition, the danger must be so obvious that the actor knows or should reasonably foresee that harm will more likely than not result from the act. Though recklessness is willful, it is not intentional in the sense that harm is intended to result. Instruction number 21. A dangerous weapon is any device or instrument designed primarily for use in inflicting death or injury, and when used in its designed manner is capable of inflicting death. It is also any sort of instrument or device actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting death. You are instructed that a firearm, such as a .22 rifle, is by law a dangerous weapon. Instruction number 22. If a person has the opportunity to deliberate and uses a dangerous weapon against another, resulting in death, you may, but are not required, to infer that the weapon was used with malice, premeditation, and specific intent to kill. Instruction number 23. Specific intent means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he or she was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required, to conclude a person intends the natural results of his or her acts. All persons involved in the commission of a crime, whether they directly commit the crime or knowingly aid and abet its commission, shall be treated in the same way. Aid and abet means to knowingly approve and agree to the commission of a crime, either by active participation in it or by knowingly advising or encouraging the act in some way before or when it is committed. Conduct following the crime may be considered only as it may tend to prove the defendant's earlier participation. Mere nearness to or presence at the scene of a crime without more evidence is not aiding and abetting. Likewise, mere knowledge of the crime is not enough to prove aiding and abetting. The guilt of a person who knowingly aids and abets the commission of a crime must be determined only on the facts which show the part she has in it and does not depend upon the degree of another person's guilt. If you find the state has proved the defendant directly committed the crime or knowingly aided and abetted other persons in commission of the crime, then the defendant is guilty of the crime charged. Murder in the first degree is contained in instruction number 12, requires a specific intent. Therefore, before you can find that Karina Cooper aided and abetted the commission of the crime of murder in the first degree, the state must prove that either Karina Cooper had such specific intent or aided and abetted with the knowledge the others who directly committed the crime had such specific intent. If Karina Cooper did not have the specific intent or knowledge the others had such specific intent, she is not guilty. Instruction number 25, for the defendant to have knowledge of something means she has conscious awareness of it. Instruction number 26, you must determine whether Karina Cooper is guilty or not guilty from the evidence and the law in these instructions. You must consider all of the instructions together. No one instruction includes all of the applicable law. You must consider the evidence. Do not be influenced by any personal, as you consider the evidence, do not be influenced by any personal sympathy, bias, prejudices, or emotions. It is common to have hidden or implicit thoughts that help us form our opinions. You are making very important decisions in this case. You must evaluate the evidence carefully. You must avoid decisions based on things such as generalizations, gut feelings, prejudices, fears, sympathies, stereotypes, or inward or outward biases. The law demands that you return a just verdict based solely on the evidence, your reason and common sense, and these instructions. As jurors, your sole duty is to find the truth and do justice. I'm going to stop there, and I will finish with the rest of the jury instructions once we finish with closing arguments. And I guess, counsel, do we need a few minutes or are we ready to go? Either way is fine.
If we could just take 5 minutes.
Okay. Well, we'll take 10. So we'll take approximately a 10-minute break, or as long as you folks all need to use the restroom or whatever you need to do, and then we will resume with closing arguments. So again, I'd remind you of the admonition I gave you previously, and we'll see you shortly.
I'm printing my materials for my torts class, and I know the printer is like super loud because it's right behind me. So I'm here, I'm muted, but I'm just looking for us something to watch for the next 10 minutes or so.
Petition challenging this guilty plea. Mr. Hardy? Yes, sir. And Mr. Robinson? Yes, sir. Do you have anything, or do you have any questions for your attorneys as it relates to how they explained and what they explained in regards to a habeas corpus petition? Mr. Hardy?
No, sir.
Mr. Robinson?
Sir.
You had this case proceeded to trial. The state was shown during that trial that on September 26th of 2022, bless you, at approximately 3 o'clock in the morning. The staff at the hotel at Old Dogwood Road in Roswell, Georgia, here in Fulton County. They were cleaning the remaining rooms that they had left to clean from people who had checked out earlier from the day before, so September 25th of 2022, when Miss Mallory Thomas and Miss Brianna Walmsley entered room 344. They found an individual, room 346. They found an individual who, the white male who had been wrapped in a sheet and had his clothes, shirt was removed and his pants were kind of down by his ankles, and he was wrapped in a sheet. They immediately called 911 because they, upon finding him, found him very badly beaten and realized that he wasn't breathing. So upon 911 being called, members of the Roswell Police Department showed up and responded to the scene. And as they began to investigate the death of the victim, in this case, Mr. Brian Gaisford, which is Gaisford, they looked at the room adjacent to room 346, which is room 344. When they were looking at room 344, they could see that a sheet had been hung to cover the window that led into, or you could see into the room. It was only halfway covered. When they peered into the room, they could see that it looked like it had been recently occupied. It was in complete disarray, and they could see what they believed to be blood stains throughout the room, on the bed, in that picture. The search warrant was applied for and then executed on room 344. Upon entering the room, they found there was 2 beds in this room versus in 346 where the victim was found. There was just one queen size bed. When they entered the room, they found that one of the beds was missing sheets, and what they were able to determine based on the sheet that was found on Mr. Gaisford that he was wrapped in, that sheet belonged to that bed in room 344. They began to process the room, and upon processing the room, they took swabs and fingerprints and things of that nature, which eventually were sent to the GBI and as well as the Roswell Police Department's crime lab. Upon the GBI's processing of swabs, they were able to determine that the blood that was found in the room 344 that was in disarray, all of the blood stains belonged to the victim, Mr. Gaisford, and they additionally were able to find fingerprints of all 4 defendants, to include Mr. Robinson and Mr. Hardy, in both rooms, Your Honor. What they then were able to do is speak to the staff at the motel in Roswell. Upon doing that, they were able to determine that the room 344, where the victim had been beaten, had been rented for the last month, and the renting of the room would have ended on October 1st, was to Mr. Michael Ryder. In order to rent the room, he had to provide his ID, pay up front, things of that nature, which they had copies and provided to the detectives. Earlier or later that day, on September 26th, around 6:30 p.m., Mr. Ryder was located nearby, close in proximity at a gas station to the hotel. He was apprehended, taken to the police station, and agreed to make a statement. He first denied that he had ever rented a room, that he was even at the location. Eventually, as he continued to speak to the detectives, he admitted to being at the scene. He admitted to being in the rooms where the beating had occurred. But what he described was that he was beat badly.
That he, Mr. Ryder, was beaten.
Yes, that he, Mr. Ryder, was beaten badly with a pole, with a pistol, with a fist, and he was badly injured, is what he said. But his visible appearance was not one that had been beaten. What he described was the beating, which was determined to have occurred to the victim, Mr. Gaisford. What they found in the room, and I neglected to tell Your Honor, was a half of a broomstick, a pole that had blood all over it. There were marks on the victim's body that was consistent with the diameter of the pole. And upon testing of the pole, the victim's blood was found all over the pole that the state contended used to beat Mr. Gaspard. As the investigation continued, Mr. Ryder was arrested on September 26th that evening. On October 6th, Mr. Lemons was taken into custody. Upon being taken into custody, Mr. Lemons did make a statement to the police. He informed the police that he worked at the location.
The hotel.
Yes. And while he was on duty on the 25th, he was asked by Mr. Robinson for cleaning products. He provided the cleaning products a short time later by taking them to room 344. When he went to room 344, he saw Mr. Hardy and Mr. Ryder in the room and was able to see inside the room where Mr. Gaspard, he said, laid in between the two beds, barely moving. He had described that he was shaking. And later that evening, he saw Mr. Hardy, who he would contend made a statement that they had to beat Mr. Gaspard up in the way that the manner in which they did because of the fact they learned he was an informant would be Mr. Lemon's testimony. Mr. Hardy was arrested on the same day, October 6th, 2022. Upon Miranda being read to him, he chose not to make a statement to the police. And about 6 months later, on January 3rd of 2023, Mr. Robinson was arrested. And I know Ms. Bumpus will correct me if I'm wrong. I believe it was Ohio. I've misplaced.
Detroit, Michigan.
Yes.
Okay.
Where I think members of his family live majority of the time. He was then, upon being taken into custody, sent to Atlanta, and at that time, he declined to make a statement as it related to the incidents that occurred in September of 2022 to the Roswell detectives, Your Honor. Had this case proceeded to trial, that's what the state would have shown beyond a reasonable doubt. Upon extensive negotiations with all counsel, the state and counsel have agreed to counts 1, 2, and 3, all being reduced to manslaughter under 16-5. That's 2. Obviously, they would only be sentenced to count 1. Counts 2 and 3 would vacate by operation of law. Counts 4 and 5, the aggravated assault counts, would merge with count 1, and they would be sentenced on counts 6 and 7. The state's recommendation, or global recommendation, based on the negotiations, is 15 years to serve 5 years. Obviously, the defendants would get credit for time served. And the state's recommendation is that that 5 years would be commuted for the time they've already served. So they'd be released based on their agreement to cooperate. And speaking with counsel, conditions of the plea would be that the defendants within a month of being released would meet with the state and provide statements as it relates to what occurred in the rooms 344 and 346 of the Roswell Hotel, and specifically describe the role in which Mr. Ryder played. In a brief summary that both counsel have provided, they have indicated that both defendants their statement would include statements that Mr. Ryder was involved in the beating, was present, things of that nature, and played an incredibly active role, not only in the beating, but in the cover-up, or attempted cover-up and concealment of the death of Mr. Gaspard. In addition, when Mr. Ryder's case is to move to a trial, both defendants have agreed that they would continue to cooperate and testify truthfully in the trial of Mr. Ryder's case, if that is to occur. Other than that, Your Honor, that's the negotiations that the state and defense counsel have had over the last couple of months, and nothing further from the state.
Okay. Thank you. Ms. Harvey from pretrial, thank you for joining us. How are you?
Good. How are you?
I'm okay. Can you share with me, please, criminal history information for Mr. Hardy first?
Yes, Your Honor. 2 cycles out of Georgia, 6 cycles out of the state of Mississippi. There is an arrest out of Mississippi from 2010 for 6 counts of armed robbery. No disposition was listed for these charges, Your Honor. However, the very next cycle indicates that he was taken into DOC custody with Mississippi. And nothing further for Mr. Hardy.
Okay, thank you. And on behalf with the criminal history information for Mr. Robinson.
Yes, Your Honor. 2 out of Georgia, 1 out of Ohio, and 16 out of Michigan. Felony convictions from 2013 for possession of controlled substance and 2019 for possession of controlled substance. Misdemeanor convictions from 2016 for domestic violence and 2021 assault on a police officer. Those are all out of Michigan, Your Honor, and nothing further.
All right, thank you so much.
You're welcome.
Mr. Hardy, we're going to start with your lawyer, Mr. Regis. What do you want to add to the discussion we've had so far?
I have nothing to add beyond I'm hoping that the court will take
All right, go ahead and have a seat, everybody. All right, we've just had a short mid-morning break. We have our jurors, counsel, and parties present. Ladies and gentlemen, at this time, as I indicated, counsel for each side are going to have the opportunity to make closing arguments. As part of their closing arguments, I anticipate counsel will be summarizing testimony and evidence that you have heard during the course of this trial. As they do that, they will be recalling the evidence as you will be later. They will not intentionally be trying to mislead you, and if your recollection of the evidence is not the same as theirs, you must follow and rely on your own recollection. The summaries, the arguments of counsel are not evidence, and they should not be construed by you as evidence or instructions on the law. They're simply intended to help you understand the positions of each side, and you should give counsel your close attention. With that, Mr. Ringel, are you prepared to present closing argument on behalf of the state?
Yes, Judge, thank you.
You may.
Ladies and gentlemen, this is exactly what it looks like. Karina Cooper, Houston Baker, murdered Ryan Cooper, shooting in the face of her children right next door. Same house. We have a woman, Karina Cooper, who hated her husband. Hated him. Referred to him as a child, referred to him as a sperm donor, said, fucking hate him. Her friends, who she described as family, who were emotional on the stand. What did they say? We heard her threaten Ryan many times. I hate you. I wish you were dead. I should shoot you in the face. Ryan Cooper was shot twice in the face. Messages between Karina Cooper and her affair partner, Houston Baker, planning and plotting the crime. Not fantasy, not a game, not a misunderstanding, not the product of data loss. They're exactly what they look like. A woman who hates her husband, who wants a new life, who wants a different life with Houston Danker. Plotting to kill her husband, whom she hates, by shooting him in the face. And that's exactly what happened. Oh, by the way, she had no money. Ryan made the financial decisions. She was unhappy with the fact that there were a lot of things she couldn't do. You saw the bank accounts. Some of them starting in the negative. Hundreds, combined thousands of dollars in overdraft fees. Not only does she get to be with her affair partner, Houston Danker, she kills her husband. She also gets more than $600,000 in her, roughly $550,000 in insurance money. Another roughly, what did Michelle Wilson tell you? $100,000 from selling Ryan's stuff. Motive? It's exactly what it looks like. The messages mean exactly what you think they mean. She's guilty, and obviously guilty, of first-degree murder. The text messages or snaps in this case, they may be the smoking gun. They may be the most obvious evidence in this case. It's not the only evidence in this case, not by far. There's layer upon layer upon layer of evidence that indicates she's guilty of murdering her husband. We're going to go through that evidence. We're going to talk about it. We're going to go through the jury instructions that will guide you during your deliberations to make sure that you understand how the law applies to the facts. They look complicated. They've been read to you. There's a lot of words in there. There's a lot of legal jargon. It's not complicated. It's actually pretty straightforward. This case is an easy one. Try to close. She's guilty beyond a reasonable doubt. The evidence shows that. Let's start with the now somewhat contested messages you've heard so much about. What do these messages possibly mean? She told her she sent them. Keep in mind, she told you a couple different things, right? Before we go through these. You can judge her credibility. It's your job to judge her credibility. She lied to the cops. She lied repeatedly to the cops. She lied over years to law enforcement. Now she wants to tell you, oh yeah, these incriminating snaps that look exactly like what they are, me plotting with Houston Danker to kill my husband, that's sort of a fantasy. Just kind of look at it online, like when you play video games, right? That's what she said. When you play video games, when you steal cars, you shoot cops. That's what this is. Some sort of fantasy. But she's also terrified of Houston Danker. She also didn't take it seriously. And what did she say about these specific messages that we're about to look at? She told you, oh, I wasn't even really paying attention. I was only half paying attention to what I said. Okay. She's terrified. It's a fantasy. She also said Houston Danker is the one that sends the messages talking about murdering her husband. Okay? So it's a fantasy that she's participating in or she's not. Same goal. It's making sense. So what are these messages? Let's start with this one, 331, not reported to law enforcement the night of the husband's killed. Heart emoji, 331. Not really paying attention. Think about data loss. Think about whether these conversations flow in a natural manner. Think about if there's anything possibly missing. There's not. Okay, here we are. Heart emoji, 2 seconds later from Houston. Seriously, more than fucking life. You can look at the defense exhibit. Those are in sequential order based on the message IDs. We'll get to the fact that the message IDs don't really relate to sequential order. Their expert couldn't tell you that. You don't need all that to make a determination of whether this is in sequential order and makes sense. Heart emoji, 2 seconds later, seriously more than fucking life. Karina says, forever. Not really paying attention to what hack read them. Doesn't really know what they say. I don't know. Oh, whatever. Okay. Remember, she's still law enforcement, none of this. Except she was asleep. More than anything. Okay, babe, phone's going down. Send me something after I leave your house to then wait for me to open it. Deal? She's not paying attention. So she said, deal. 8 seconds later. Seems like she's paying attention. She's directly responding to what he said. There's no mystery here. She can try to talk around it as much as she wants. Consult. It's ridiculous. Deal. Aiding and abetting. Deal. 3 seconds later. Kiss emoji, not paying attention though. Can't really read what's going on. Houston, remember those casings. Fucking remember those. No ifs, ands, or buts. She seems to be tracking the conversation pretty well. She's responding to everything that he said. She doesn't say, what are you talking about? What casings? I don't know what a casing is. No, she doesn't say. She says, absolutely, 100%. 14 seconds later. Is what she's telling you credible at all? Wasn't paying attention. Don't really know what it means, what's going on. Seems to be tracking. Okay, phone's going down. I love you. I love you too. So much. Forever. Okay, babe, seriously, putting the phone down. Have to get this shit done. I love you. She doesn't say, what are you talking about? What does this mean? Because the plan to murder Ryan is already in place. All of the necessary conditions for this murder to happen are in place. Planned by Karina and Houston for months. This is the night it's going to go down. This is the night it's going to happen. She confirms, because she controls the scene, that everything that needs to be in place for this murder to happen is in place. You saw the searches. You know they did a ton of internet research. They thought they were going to commit the perfect crime. Putting the phone down. Why are we putting the phones down? Because they know a little bit about digital forensics. They know a little bit about location data. This is supposed to be some sort of convoluted alibi. Houston's at least smart enough to know I probably shouldn't take my phone with me when I go commit the murder. Because they're a little bit savvy. But the funny thing is, when you commit a murder, there's a lot of things you don't know. Investigators know them. Detectives know them. Forensic scientists know them. They didn't know. One of the things they didn't know, your snap messages that you think you've deleted can be recovered. All the conditions are in place. Scene is controlled. Ryan's where he's supposed to be. Kids are subdued. Ransom is subdued. We'll get you in the door. You and I shoot Ryan. We get on with our lives. Go. He said, have to get this shit done. He said, what are you talking about? Consistent with their plan, she said, go. That is Ryan's death warrant. Signed by Karina. Then, yeah, just look up. Again, convoluted attempt at phone and data manipulation to throw off investigators. The same way that Karina, for years, sought to throw off the investigators. She can't tell anybody what happened to Ryan. Won't tell anybody what happened to Ryan. And whenever she opened her mouth to talk about it, provable lies, over and over again. She's guilty of murder in the first degree. How do we get there? What are the elements of murder in the first degree? On or about June 18th, 2021, Karina Cooper shot Ryan Cooper, or aided and abetted Houston Danker in shooting Ryan Cooper. The state has to and has proven that beyond reasonable doubt. Ryan Cooper died as a result of being shot. Karina Cooper individually, or Houston Danker, aided and abetted by Karina Cooper, acted with malice and forethought. We'll talk about what that means. It's been established. Karina Cooper individually, or Houston Danker, aided and abetted by Karina Cooper, acted willfully, deliberately, premeditatedly, and with specific intent to kill Ryan Cooper. Yes, that happened. It's been proven beyond a reasonable doubt. You're being presented with what's called alternative theories. Karina Cooper shot Ryan Cooper, one theory, or aided and abetted Houston Danker in shooting Ryan Cooper. That's another theory. Alternate theories. What does that mean? It's not complicated. If you find that she aided and abetted Houston Danker in shooting her husband, she's guilty of first-degree murder. If you find that she shot Ryan Cooper herself, she's guilty of first-degree murder. Either one. Either or. This is about a unanimous verdict. What this says is, where two or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It's the verdict itself which must be unanimous, not the theory upon which it's based. May be confusing. What does that mean? Simple and straightforward. It means some of you may think she aided and abetted Houston Danker. The remainder of you may think that she herself shot Ryan Cooper. That's guilty. Because all of you think she committed first-degree murder. It doesn't matter how. Some of you may think it's aiding and abetting. Some of you may think she pulled the trigger. That's okay. You don't all have to agree she pulled the trigger. You don't all have to agree that she aided and abetted. Either or. And she's guilty of first-degree murder. What does aid and abet mean? So we have, she pulled the trigger herself, or she aided and abetted. What is that? Knowingly approve and agree to the commission of a crime. By active participation, there was active participation. Or by knowingly advising or encouraging the act in some way before or when it's committed. Go. Certainly not all she did. Again, we'll go through her control of the scene and the conditions that had to be in place for Houston Danker to come over and participate with Karina Cooper in murdering Ryan Cooper. But she's certainly guilty of aiding and abetting. There's a mountain of evidence that establishes that. Now, there's some additional instruction under aid and abet that may seem confusing. Murder in the first degree requires a specific intent. In order to find that she aided and abetted Houston Danker, you must find either that she, Karina Cooper, had that specific intent, or Houston Danker did and she knew that he did. We'll talk a little more about specific intent. It's pretty clear they both want Ryan Cooper dead. It's pretty clear she knows it. She told us she knows it. In her version of events, she's been hearing from Houston all the time about shell casings and how he wants to kill Ryan. So does she. It's pretty clear from those snap messages they have a specific intent. 2 shots to the face. That's specific intent. There's more. There's no question that she had the specific intent. There's no question that she knew Houston had the specific intent. So it's not an issue with regard to aid and abet. It's already been established. It also says this: mere nearness to or presence at the scene of a crime without more evidence is not aiding and abetting. There's plenty more evidence. Those snap messages alone are plenty more evidence. She didn't just happen to be there. This just means that she had to act in the commission of the crime itself. Not even necessarily that night. She did. She did participate that night. Just means there has to be more evidence than the fact that she just happened to be there. We know she didn't just happen to be there. Similarly, mere knowledge of the crime is not enough to prove aiding and abetting. In other words, just because she knows about it, one way or another, that's not enough for aiding and abetting. We have far more than that. Again, active participation. Already established beyond a reasonable doubt. So, we go through the elements one at a time, talk about some of the evidence that establishes guilt beyond a reasonable doubt for each of those elements. Here are the elements again. Let's start with number 2. This one's easy. Ryan Cooper died as a result of being shot. Medical examiner, Dr. Kelly Cruz. What did she tell you? Cause of death, gunshots to the face. Wound A, fatal. Wound B, fatal. Ryan Cooper died as a result of being shot. Proven beyond a reasonable doubt. Her testimony, the autopsy, that's established. Moving on to number 3. Karina Cooper individually, or Houston Danker, aided and abetted by Karina Cooper, acted with malice aforethought. What is malice? Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. This is distinguished from an act done in the heat of passion. How may it be established? By evidence of actual hatred or proof of a a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful or injurious act, in this case, firearm. So were these acts born of actual hatred? Yeah. Malice also requires such deliberation that make a person appreciate and understand the nature of the act and its consequences. Again, as distinguished from the act done with the impact. Malice aforethought does not have to exist for any particular length of time. Malice and malice aforethought may be inferred from the use of a dangerous weapon. Everything that we just read, everything that it said, you can infer by the fact that a dangerous weapon was used. And you received an instruction. A .22 rifle, by law, is a dangerous weapon. That's the weapon that killed Ryan Cooper. So malice and malice aforethought are already established by the fact they shot him in the face with a .22 rifle. You don't have to think about anything else with regard to malice and malice aforethought. It's already established. When you shoot someone in the face with a .22 rifle, malice aforethought can be inferred. There's more evidence of malice in this case. We talked about this just briefly. Teresa McBride. Karina told you, she's family. She didn't describe her as a friend, she described her as family. Malice. Actual hatred. Said she hated Ryan multiple times. Said she wished he was dead. That's malice. Heard Karina say she would shoot him in the face. Malice, aforethought. This is well before the murder. Brian Morrison, same, family. You saw him on the stand. You judge people's credibility. He was very emotional. You lost his friend, Brian. He also loved Karina. He also knew exactly what she said. She would shoot him in the face. Everything's a fantasy with Karina. Everything's a funny joke. It's a misunderstanding. It's a joke. Thought I'd shoot him in the face. It's a joke. They didn't take it as a joke. They said it was time to go. And they left. That's her family. They left because it wasn't a joke. If it was a joke, they would have laughed. The snaps are a joke. Saying I hate him, shoot him in the face, that's a joke. Conversations with law enforcement, joke. Tell them whatever you want. The testimony, joke. Additional evidence of malice. Karina's own words. Fucking hate him. What do we think that means? It means she hates him. This is to Houston. This is in February. She's mortified, right? She's so scared of him. She doesn't want to have anything to do with him. Doesn't want anything to happen to her family. So these are the messages you send back and forth. Gee, I hate my husband. I wish you were my husband. You should be a father to my kids. Not my sperm donor. Not this child. It's terrible. What else did she say? Like I said, sperm donor. She hates him. She resents him. She wants him dead. She wants Houston Danker to father and parent her children. She says that. Here's hoping for a rogue semi today. Big accident, no survivors. Who drives a semi? Her husband, Brian. I broke it off with Houston. We had sex once, but I shut it down. Didn't want anything to happen to my family. And then I text him, you should father my kids. I hope Brian dies in a semi-accident. Malice aforethought. You can infer it from the use of a weapon. There's plenty of other things. Number 4, Karina Cooper individually or Houston Danker aided and abetted by Karina Cooper who acted willfully, deliberately, premeditatedly, and with a specific intent to kill Ryan Cooper. Again, that seems like a lot. Again, it's actually pretty straightforward. Willfully, fixed design or purpose. Pretty clear what their design or purpose was. Certainly pretty clear what your design or purpose is when you shoot someone in the face twice. Deliberate. Having deliberated, which is to weigh in one's mind to consider, to contemplate, or to reflect. She's talking about hoping he's dead months before they kill him. That deliberation doesn't have to exist for any period of time. It could be while you're sighting your husband who's sitting in a recliner with a rifle. It could be when you're loading the ammunition. It could be when you're pulling the trigger. It could be in between the first and second shot. Here we have months. Not even close. Premeditate. Think or ponder upon a matter before acting. Say. What is specific intent? Not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. What's the act? Shooting Ryan Cooper in the face. Specific purpose, to kill him. This is not complicated. You may, but are not required to conclude a person intends the natural results of his acts. What's the natural result of shooting somebody twice in the head? That you're going to kill them. Again, if a person has the opportunity to deliberate, which we just established, they both did, and uses a dangerous weapon, that's a 22, against another resulting in death, you may, you're not required to, infer that the weapon was used with all of these: malice, premeditation, and specific intent to kill. The use of the 22 rifle alone establishes all of these things. There's plenty of evidence, and you've heard it repeatedly over the last week, for all of these: premeditation, specific intent, malice. As long as you find there was time to deliberate and deliberation occurred, you don't need to weigh any of that evidence for this element. Just look at the fact that the 22 rifle was used. As I said before, 22 rifle is by law a dangerous weapon. Specific intent to kill. It's already established by the use of the weapon, but let's talk about other evidence of specific intent to kill. She and Houston shot her. We know she was up, she was around that house for an extended period of time. We'll go through the timeline, not the timeline she provided, but the timeline established by clinical forensics. What did she do? She's awake. She told you. She told you both, right? You think about her testimony on the stand. What did she say yesterday? She woke up because she heard a crash. Sticking to that story. But she also admitted to sending all the snaps. Okay? So apparently she was both awake and asleep and awakened by a lot of pressure. She was awake. She participated in the murder. That's what really happened. Then she staged the scene, taking care of some other things that needed to be taken care of, which we'll talk about later. All the while, Ryan's bleeding out. He's dying. His blood is drying. His blood is clotting. Two separate things. She finally gets around to calling 911 when she's good and ready. Has the scene set the way that she would like it to be set up. She calls in. Fake hysterics. Ridiculous, dramatic, overacting. She calls in. Volunteer firefighter. And she says, I think somebody's in my house. Not a word about Ryan. Not call an ambulance. Not call 911. Not get help. Not you come over here. He needs some aid. I think someone's in my house. Okay. I think someone's in your house. You're running around in the house. You're unarmed. Apparently you think someone's in the house. She's buying time, making it look like she's doing what a reasonable person would do if they found their husband shot. I called for help. Did you know? Did you really? Or did you fake call for help? Someone's in my house. What's going on? Screaming. Can we get any details? Screaming. Okay. Never mentioned anything about Ryan when calling Aaron. Something to think about. For news story, Houston Baker did it. And I was so scared I didn't tell anybody. What does this have to do with Houston Baker? How does this help Houston Baker? If Houston Baker murdered her husband or shot her husband, she didn't want to tell that Houston Baker did it because she's afraid she'll get in trouble. How does that prevent her from calling 911 immediately and telling them what happened? You can say, I don't know who did it, but you can also say, we need some help right away. How does providing misleading information about the timeline come forward with her story that Houston Baker did? Are these all cover stories that help her because she participated in the murder? Exactly. If you're concerned that Houston Baker did it, you had nothing to do with it, you don't want them to be upset with you would just help as much as you can and say, I don't know anything about who did it. She did it. She told a series of lies that helped her because she's participating in the murder. Never asked Aaron to call 911 or an ambulance. Never told Aaron that Ryan needed aid. She never attempted to render any aid herself. Like any normal, reasonable person, she did nothing. Until eventually sat on it. We'll talk about that more later. She sat on it. She rubbed her face all over the blood to conceal evidence, to conceal her role in the murder. Two shots to the face, specific intent to kill. Opportunity to deliberate. These are the messages from before the murder. Opportunity to deliberate. We have plenty of other messages where she wants him dead. But here we are at 3:30. She makes her fake cry for help at 4:30. Here's an hour before. Okay, come over to murder your husband. Don't forget to pick up the shell casings. Absolutely 100%. Opportunity to deliberate. Yep. Phone manipulation, phone's going down. I love you so much. Forever. Okay, gotta get this shit done. Go. This has been proven beyond a reasonable doubt. There's more evidence that supports it. You've heard it. It's probably in your notes. Not going to go through all of it. This is by far more than enough to establish beyond a reasonable doubt. Houston Danker, aided and abetted by Karina, or Karina herself, acted willfully, deliberately, premeditatedly, and with specific intent. And again, remember, you find deliberation, the use of the .22 rifle is enough for you to find reasonable doubt that's been established beyond a reasonable doubt for element number 4. 3 of the 4 elements are already met. The final element. On or about June 18th, 2021. That's not in question. All the first responders, everybody talked about, and everyone else. This occurred on June 18th, 2021. Karina agrees. Karina Cooper shot Brian Cooper, or aided and abetted Houston Danker in shooting Brian Cooper. Did she? She did. Brian's murder absolutely could not have happened without Karina's aid. By her own account. Which, by the way, is ridiculous. Let's talk about the things that she had to do to make this murder happen. Here's the plan. Karina decides with Houston, ultimately, that they're going to shoot Brian in his house while he's asleep. The kids have to be there. Why? Well, if that's your plan, it would look really suspicious if the night that your husband is murdered just happens to be the night that the kids are at Grant's. So she had to make a decision. And she did. But this murder would happen while her kids were present. It would just look too suspicious if they weren't. She tells you, I would never orchestrate a murder with my kids there. Watch Officer Bain's body camera. She's just gotten through concealing evidence by rubbing her face all over Ryan's dead body. Her children are in the room. She's pretending to be upset. Different people respond differently to trauma. We know that. Look at everyone else at this scene, including the children. Pretty calm. Their dad's lying dead. Blood everywhere. Their mom is screaming hysterically. Look at the kids. Were they able to talk and communicate with law enforcement? Yeah. Aaron came in, finds his brother dead. Blood everywhere. Was he able to communicate? Yeah. Karina cares about her kids. I told you that. She would never orchestrate a murder with the kids there. Well, she had to. Be pretty suspicious otherwise. She's so caught up in trying to convince law enforcement that she's devastated by the death of her husband that she knows nothing about. But her children are standing right there in the room. And she walks right past them out of the room. Doesn't look at them. Doesn't comfort them. Doesn't care. Because she's got a job to do at this point. She just murdered her husband. And she has to convince everyone. She's devastated. She can't even breathe. She can't talk. Spoken. She did orchestrate a murder with her kids there. She had to. It's too suspicious of it. So, what did she have to do? What was part of her job in this case? How's she going to get this murder done? Problem number one. Hey, sleeps next to Ryan, but we want to shoot in the face. Got to get him out of there. You heard Kate's testimony. He had been sleeping next to Ryan for a year. For a year. She told him, you gotta sleep in your own room. She tries to pass it off. Oh, it's part of our deal. We had a deal, we're gonna redecorate the rooms, and we're gonna redecorate the rooms, and then they gotta go sleep with them. Wanted to get the kids in their rooms before school started. It's June. Early June. That's her phony cover story. This is evidence of deliberation and premeditation. They've been planning this murder for a long time. Long enough for her to come up with this phony excuse of painting the rooms. You can see that she's working on the house. You can see she's been painting. That's evidence. That's evidence of premeditation. She's hoping that her husband will be dead months before this. Problem number one. Kids are going to be home. Let's get Cade up to his room. He can't be there when Ryan's shot in the face. Mission accomplished. She had to assure Portland and Cable were asleep and accounted for. 2 other kids who can't see what's going on. They didn't have to sleep in their own rooms that night. They were with her, where she could keep an eye on them. What else had to be in place for this murder to happen? She had to assure Ryan was asleep. That's a big one. That's why we're texting at 3:30 in the morning, let's do this. That's why it didn't happen at 6 p.m. or 6 a.m. or midnight. Who knows his sleep schedule? Karina does. That's a crucial part of this murder. She knows. What did she tell you in the interviews on the stand? He's like his dad. He's up roaming in the night. That's why she says go. Everything's in place. Ryan's asleep for the night. She knows his sleep schedule. It's not a normal one. Falls asleep around 8. Sleeps for a little while. Gets up. Watches TV. Eventually falls back to sleep. He's up roaming in the night. Kate's in his room. Kids are with her in the bedroom. She's confirmed Ryan's asleep. Go. He's asleep for the night. There's also a gun in the house. This is her boyfriend. She refers to him essentially as a husband. Says Houston Danker is her husband. She's his wife. She's worried about him. There's guns in the house. You heard, she doesn't know anything about guns. But everywhere she goes, there's guns. She had to get a weapons permit because every car I get in, there's a gun. She told police she doesn't know anything about guns. But she knows there's a gun in the house. If there's a confrontation, if Ryan's awake, Houston could get shot. She can't have that. Just to make sure there won't be a confrontation. She has to make sure that Ryan's asleep. Security. Think Houston Banker could do this by himself? Think he chanced it just right? That he happened to come over, he happened to pick the right door, door just happened to be unlocked, happened to be able to get in through the house at a time when Kate wasn't up, just happened to not be sleeping next to his dad. He's only been 2 days, that doesn't mean anything. The other kids just happened to not be awake. Ryan just happened to be asleep for the night. Security. These are security-conscious people. You saw the crime scene photographs. Locks on all the doors. Karina told you multiple times, the door behind Ryan, locked. 99.9% sure. Locked. Kitchen door just happened to be open. She had to make sure he could get in. And then he could get in to a situation that was controlled. Ransom. 130-pound Rottweiler. What she stated to Ryan Herman. Very protective. Barks at everything. Would be raising hell if he heard anything. She has to subdue Ransom. You saw Feynman's body camera. When that dog is around Karina, he's subdued. He's calm. She told you. She told officer, she told Agent Herman. Dog would raise hell if he heard anything. So now we have Houston Banker somehow getting in, coming into the house. What else did she tell you about Ransom? She left the door open because Ransom wanders the house. This very protective 130-pound Rottweiler wanders the house. They'll go upstairs to see Kate. They'll go hang out by Ryan. The target of this assassination plot, wandering the house. She has to make sure that Ransom is subdued, and she does that. Ransom is in the bedroom with her. Not going to be a problem for Houston. As I said, she has to ensure that Ryan is sound asleep for the night, and she did. She told you in her own testimony at 3:30 in the morning. She was fully aware at 3:30 in the morning that Kate was upstairs and that Ryan was asleep. When did those Snapchat messages start? Around 3:30. Go. She told me. Tells him go and sets the plan in motion. What else did she do? She helped him escape. Because he can't be seen by the children. So she has to immediately subdue him. You know who can be at the scene? She can. Those kids are going to wake up. They're going to hear something. That's a concern. If they see mom, that's okay. Can't see Houston. Kate already knows who Houston is. She broke it off. She'll never want to be with him, you know. Sort of an online thing. But Kate's simple. Then he comes over and hangs out, drinks with my mom. When dad's not around. Okay. So she has to help him escape. How does she do that? As soon as the shooting happens, we'll talk about this more. Houston's right out that door behind Ryan. He didn't come in it. Definitely went out. Karina runs to make sure that no kids are coming into the room, whether at the base of the stairs, which go to the Kate's room, or in that same room that has the doorway to the bedroom where Cortland and Kate were. pretty obvious how she bought time. We'll talk about that more. But if they didn't hear anything, or they didn't get up, she has even more time to work the scene before she fake calls for help. But the bottom line is, when she's planning this crime in Houston, they know he has to get out of there immediately, and she has to make sure the kids don't see it. Easy. She's done all those things. Made sure Houston could get it. Made sure ransom wasn't a problem. Made sure the kids weren't a problem. Made sure Cleve was in his own room. Made sure Houston could escape. Let's think about this. How do we know they're working together? Houston Danker did not come armed for a confrontation. You heard the testimony. He owns an AR-15, that's an assault rifle. Large caliber. If Houston Danker did this alone, let's think this through. He's going to come over to this house that we just talked about, has multiple security threats. We have dogs. We have kids. We have locks. We don't know if Ryan's awake or asleep. He's going over there to murder somebody. By himself. And from his arsenal of weapons, which includes a double-barrel shotgun and an AR-15, he chooses a squirrel rifle, a small caliber .22. Does that make any sense at all? Yeah, it does. If you know there won't be a confrontation. Because Karina's told you there won't be a confrontation. Because she knew at 3:30 that Ryan was asleep. She knew all the conditions were in place. She knew he wasn't going to have any problem. She knew Ryan wasn't going to be confined. She knew Ryan wouldn't have his gun. She knew all we're going to need is that .22. The .22, but as you heard the testimony of some of her friends, a .22 is a weapon that she likes to shoot. She shoots so much more easily. Doesn't have as much kickback as her weapon, that she knows nothing about. He knew there would be a confrontation because he's working in concert with Karina. You don't choose a .22 to go to someone's house and murder them unless you know there won't be a confrontation. When it was clear there wasn't going to be a confrontation, she said, duh. And he came over with his .22. So, let's talk about the floor plan. We know Karina wishes she had a larger bathroom. She told us that yesterday, so yeah, the bathroom's a little out of proportion. We've established, and you've heard, that this garage door just goes to the garage. Can't get in the house that way, right? This is the door behind Ryan. You're rolling up on the house. Here's Houston Danker. You got your .22 because you're ready for this confrontation that's going to occur. What are your options? Kitchen door, where everyone goes in. Door behind Ryan Cooper. Let's start with the door behind Ryan Cooper. Got your .22. He's asleep in the chair. You saw the pictures. You heard the testimony. You heard from Karina as well. That door, one, always locked. So what happens if you first try the door? You got your gun, you try the door, it doesn't open. Well, you probably just alerted the person that you're going to murder. It's probably not going to go in the door for that reason. Let's say it happens to be open, and for testimony that it was locked. You got your rifle, you come in, the door is going to hit the back of the chair, we already heard that. So you'd have to come in, possibly hit the back of the chair, possibly alerting the person that you're going to murder. Another reason not to use that entrance. Then, you would have to gingerly step around them with your rifle, come around and shoot them in the face, hopefully not waking them up as you shuffle by. Again, ignoring all the other objective realities that we know about dogs, kids, everything else. Okay, that makes no sense. Doesn't make any sense at all. If you wanted to kill Ryan by himself, you could have just shot him through the window with his AR-15. Done. But he didn't want to kill Ryan by himself. He wanted to kill Ryan with Karina Cooper. That's what they did. So, that leaves one option. The mudroom. That's the door he had to come in. So he didn't enter the door, behind Ryan, through the mudroom and through the kitchen. So what does that mean? She calls it the sewing room. It's labeled here as a hallway. He's going to have to, with his .22 rifle, walk past the stairs that lead to Kate's bedroom. Seems risky. The bedroom door that's open, that has Karina, 130-pound Rottweiler, ransom, 2 young children. So he would have had to walk past this hallway, past these doors. We know, Karina says, I heard a crash, I got up, I thought it was in the bathroom, so I went to the kitchen. She also says she was awake sending snaps. So, in one of her versions of events, Houston must have come in the house with his .22, happened to pick the right door, came to the kitchen, walked right past Ransom, walked right past Karina, who was both awake and asleep, walked right past the kids, didn't wake up Cade, Ryan just happened to be asleep, got himself in there, and shot him in the face. That makes no sense. It's ridiculous. It's insulting. It's not. She controlled the scene. She controlled all those threats. That's why they chose the .22. She likes to shoot the .22. None of that happened. He came in that door all right, with Karina's help. He walked down that hallway because Karina knew the kids were asleep and Kate was asleep and Ryan was asleep. Ransom had been subdued. Talked about this a little bit. Other ways that we know Karina was involved. If she says that this was Houston, it wasn't her, and her new story, which years later, this is what she's come up with, I was scared, so I can say, why are you telling the police stories that only help yourself? Why are you telling the police stories that have to do with your guilt? She's not guilty of anything. Why is she trying to throw him off the trail as it relates to her? There's one answer. Because she murdered her husband. She told Deputy Foster she's never shot a gun before. What does that have to do with Houston Bank? It has to do with her. She doesn't want them to think that she knows how to shoot a gun. She doesn't want them to think that maybe she did it, because she did. Never shot a gun before. She told Deputy Foster she's never even heard a gunshot. Maybe on TV. She has a weapons permit. She has preferences for the types of weapons that she likes to shoot. The concealed carry class was held on the property. You heard that she fired a weapon. Why is she telling me this? Because she's trying to throw them off from the trail that leads directly back to her. This has nothing to do with her story that I didn't tell her anything because I was scared of this today. You would just say, I don't know what happened. She's worried about getting caught. You'll notice, if you watch Fangman and Foster's body cams again, she can't provide any information. Anytime they ask for information, she just starts wailing and screaming. Ask Foster and Fangman both, plenty of experience. But scenes involving trauma, severe injury? Ever seen anything like that? I've not. Why do you say that? Never seen someone who couldn't provide any information to law enforcement. And the problem is, whenever she talked, the information that she provided are things that would help her. Somehow she was able to say those things. How much did she say about Ryan, what happened to Ryan? Almost nothing. There was a stream of words and phrases related to guns. My stupid gun that I've never even shot, that I don't know anything about, that I couldn't get out of the safe, and I don't even know how to use it, and I'm scared. That's a lot of information. Thank you. Can you tell us anything about Ryan? No. Karina, Deputy Foster over here. Karina. We're trying to figure out what happened. Screaming. Karina, we're trying to figure out what happened. I want my kids. Did it sound like a gunshot? That one I can answer. Never even heard a gunshot before. Maybe on TV. The only stuff she wants to talk about is stuff she thinks is going to help her, but she's guilty. She's afraid of her own 380. She's never shot it. She couldn't get the gun safe open. Why did she say this? Because she knows, one, law enforcement's probably going to find it. Two, people know she has a 380. They're going to wonder, why didn't you help? There's an intruder. She didn't get her 380 because she participated in the murder. Could she tell Foster? I tried to get it open, but I couldn't get it open. What did Foster tell you? I went and I opened it. Do you have a code or a combination? Have you ever seen that safe before? No. She thinks she's helping herself. The stories she's telling make no sense. They're designed only to help her. It has nothing to do with these things. Because she participated in the murder. You don't need to say any of that stuff. If her version of events is true, if her version of events that Houston did it and she's scared, why all this? Because that's not what happened. She participated in the murder. Doesn't know anything about guns. Then she tells you, I know, this looks suspicious, but I was taking a hunting safety course. Doesn't know anything about guns, but hunter safety course. 80-some screenshots, so she cheat on the tests, right? That's what she said. What's in that? Doesn't know what shell casing is, had to call Aaron when she saw the article in the newspaper. Is something from a shell casing? You know what that? I don't know what shell casing is. This is what's on her phone. You're trying to say Houston Danker did this, you didn't know anything about it. Why are you placing a phone call to Aaron, whom you've never talked to about what happened the night of his brother's death? Why are you placing a phone call to Aaron to pretend you don't know what a shell casing is? That's about her and her guilt. That's why she did that. She knows what shell casing is. She's taking tests on her phone. She knows what round nose lead is, good penetration, little expansion. She knows what a full metal jacket is. She knows here about projectile range and how it can help you determine whether or not you can make a clean kill. Doesn't know anything about guns though. And when she testifies, yeah, that looks bad. I got a new story. New story is about Cygnus Hunter, of course, and okay, yeah. All right, when you commit a murder, there are many things that you do not know. Many things you don't know. Karina and Houston thought they were smarter than her. Karina and Houston thought they did their research. They thought that they planned the perfect crime. There's no such thing. And they made many, many mistakes. We'll get to many of them, but let's start with her own version of events. Let's start with this. In the chaos of murdering her husband and pretending she had no idea what was going on, she told 911 that her husband was shot. It's on the 911 call. Interview with DCI agent Rick Ron and Ryan Herman. They told her repeatedly, we're just trying to figure out what happened to Ryan. Could be medical, we don't know. We're not sure what's going on. She's just sad. Didn't say anything. Didn't say a word. I don't either. She forgot that she told 911 that her husband was shot. She tells them the same thing in the second interview, and she talks about how she was trying to figure out where the blood was coming from and what happened. So it's not just that Rick Ron and Ryan Herman said, we're trying to figure out what's going on, and she said nothing. She also affirmatively said, I was just trying to figure out where the blood was coming from. No idea. She forgot that she told 911 that her husband had been shot. Okay. She told Deputy Foster on the body cam, the dog was barking. Well, fast forward a few hours later, when she's talking to Ryan Herman, Ransom never barked. She can't figure it out. There's no idea to bark. During the second interview, they talked more about Ransom. And she said, yeah, he just sort of made a noise to sort of like let the air out of his lungs. Ryan Herman said, let the air out? Yeah, just this soft. The dog was barking, she screamed while she was on the ground in fake hysterics, unable to tell officers anything about what happened to Ryan. This doesn't have anything to do with use of anger. Let's do with Karina Cooper. Her timeline. It's not even really worth going through, frankly. It's ridiculous. She gave you 2 timelines at the same time yesterday. It's clearly phony. We have the Snapchat conversations at 3:31. Never reported that to police, right? Claims she was asleep. She's doing stuff on her phone. She takes 170 steps that she never told anybody about, approaching multiple football fields. Then she called Aaron Cooper eventually when she got around to it, and then we see when the deputies arrive. Her version of events, initially, it seems like we have 2 versions of events at this point. One of them was, well, yeah, no, I was asleep. I got up and I heard a sound, went to the kitchen. Well, first she looked in at Ryan, she didn't see him. So then she heard a sound, she thought it was in her bathroom, so she goes to the kitchen and looks out the window. Okay. Then she goes in, pissed at Ryan, steps in and she finds that he's dead. So seconds, maybe 30 seconds. Agent Villada asked, hey, when you heard that sound, how long did you stay in bed? She said 5 to 10 seconds. So we have the sound, right? She gets up. Those are the things we just discussed, roughly 30 seconds. She tells you, Ryan's blood, it's like chunks, clotting. Okay? We heard from Ken Martin, that happened in 30 seconds? No, no way. There's things you don't know when you commit a murder. She doesn't know how blood works. She doesn't understand blood evidence. Her steps. Didn't occur to her when she's carrying her phone around, she's going to be recording those steps. Those steps started at 4:23. 7 minutes before the call failed. Things you don't know. Her house is tiny. 45 feet by 45 feet roughly. Very small space. You got furniture in there as well. She testified that she went back and forth between the kitchen and the living room a couple times to get Kate and get him in the room, lock herself in there. That doesn't account for steps starting at 423 of almost 400 feet. She didn't know investigators were going to find any of this stuff. So she thinks, when she sits down and talks to Agent Herman, that her story might hold up. It just keeps going and going. Many, many steps starting at 423. Because she staged the scene. Talked about the blood clots and the dried blood. Biggest mistake probably, data forensics. The snaps were recovered, the other information from her phone. Even without all that stuff, her story about Houston Danker coming over with a 22 and making his way through the house makes no sense. She aided and abetted Houston in doing this. Or she did it herself. The evidence establishes that beyond a reasonable doubt. You will see that you have some lesser included offenses in the packet. The judge talked about them. Second-degree murder and others. This is not a second-degree murder. If you find her guilty of first-degree murder, which has been proven beyond a reasonable doubt, you do not need to consider the lesser included offenses. You are done. That is only if you believe she did not commit first-degree murder. The evidence establishes beyond a reasonable doubt that she did. Motive. We just went through the elements. All of them have been established. You might have noticed motive is not on here. The state does not have to establish motive. It does not need to be proven beyond a reasonable doubt. You can consider it. We already talked about the fact that she had a financial motive. Here's her account for the month that her husband was killed. $186. Here's her business account, minus $297. Here's the insurance check she got, $514,000. There was another one that she saw for $24,000. Sold roughly another $100,000 worth of stuff. That's a motive. Here's a motive. She's in love with Houston Danker. She wants to have his kids. Start a new life with him. You might hear from the defense, hey, it doesn't make any sense that she would kill Ryan because Ryan was the primary breadwinner. Yeah, that was supposed to be Houston Danker once Ryan was dead, with a nice head start of $600,000. Karina's news story. We already talked about this. I think she was only half paying attention and didn't really read them. We already talked about that. That's absurd. These messages make perfect sense in order. There's no mystery as to what they say. There's no mystery as to what they mean. They mean exactly what you think they mean. Claims Houston threatened. Keep in mind, there's no evidence to support this claim. Data forensics. Look at the phones. Defense has this information too. This SWAT pulled it up for you. It was going through it with Tiffany Lord. No threats. Defense doesn't have a burden, but they could present you with those threats. Karina knows how to take screenshots on her phone. Any screenshots of any threats from Houston? No. What's the only evidence that these threats ever happened? Karina's word. And she sat there on the stand and told you that she lied and lied and lied for years. And she also told you things that weren't true. 2 timelines at the same time. You are the judges of credibility. No evidence of these threats but her word. Her reaction to the threats doesn't make any sense at all. Well, he was making threatening statements about Ryan, so she calls herself his wife, insults her husband, talks about her husband dying, wants him dead. This is another one she testified to. She had hair appointments on the morning of June 18th, the morning that Ryan was killed. She couldn't have killed him, she had regular hair appointments. It's ridiculous. Go to sleep. First of all, the messages are in sequential order. You can read them. Would it make any sense after what we just said? Absolutely 100% deal. We're going to murder my husband. We know why she said go. The scene was staged, the scene was set, no confrontation was going to happen. She now says, oh no, there was some follow-up messages. Much like the threats, there's no evidence of them. And I said, go to sleep. Makes no sense in the flow of the conversation. It doesn't matter what you think about the data forensics. Tiffany Ward told you it's not possible. Defense brought in an expert who says, well, I didn't test anything and I don't know how the mechanism works, but there's a column of numbers and they're not sequential. Mr. Kodiaga said, could that just be related to the time between when the messages are sent versus each message getting an individual number? Maybe, I don't really know. Tiffany Ward told you it's not possible. It has nothing to do with that column of numbers. That column of numbers does not indicate missing messages. That's not at all what that means. There's been no testimony that that's what that means. The expert that they brought in said, I don't know, I haven't tested anything, and I don't know how the mechanism works. Tiffany Ward is aware of that column of numbers because Ms. Watt asked her about it. It's not like this is a mystery to her. She said it's some proprietary information, I don't know exactly how it works. Nonetheless, it's not possible, based on the information that she has, for there to be additional messages. Regardless, common sense and reason. Read the snaps. Look at what happened. Makes no sense. She didn't say go to sleep. She said go. What are the chances that somehow all the information that's exculpatory, the threats and the additional messages that show up, it was just, I didn't do it. But just somehow that wasn't happening. So Karina wants you to believe. It's like she wants you to believe all the different stories she's told. Makes no sense. She's guilty of murder in the first degree. The state's proven it beyond a reasonable doubt. At the close of evidence, we're asking that you find her guilty. Thank you.
All right, ladies and gentlemen, we're going to take approximately a 15-minute break now. We've been going about an hour and a half or so. Give everybody a chance to use the restrooms. And so take a 15-minute break, and then we'll come back and resume closing arguments. Again, I would remind you of the admonition that I've given you previously.
Into consideration the extensive negotiations that I've had with the state. I hope the court will respect the fact that we have a significant amount of time and energy, and we've looked at this from every conceivable angle. And I hope in so doing, the court will sentence Mr. Hardy as the state and I have discussed, negotiated, and fought for. I think it's a very fair resolution, and I think the ends of justice are served by this resolution as we've negotiated.
Okay, Mr. Hardy, anything you want to add? Mr. Hardy, when you are released, are you staying locally, meaning in Georgia?
Yes, sir.
Okay. Do you have family in the Atlanta area? All right. Thank you. Ms. Bumpus, what do you want to add on behalf of Mr. Robinson?
Your Honor, my sentiments are the same as Attorney Regis. I just would like to add, this plea is, I know, ADA Bate stated it's non-negotiated, but it is non-negotiated, not at our fault, as one of the terms is something that we could not control. So I would ask that, even though it's non-negotiated, it's kind of negotiated, and that you consider that when looking at sentencing. Just as Attorney Regis stated, we have worked really hard on this, and I speak for my client, and I know his client too, just from what I know, they take this very serious. And this was a very tough decision for my client, a very tough decision, but he is accepting responsibility, and he does want to try to get back to his family, his mother who is sick, and his 5 children who really need him. And we just are asking that the court accept this. He would, I know you just asked him started, but he would be asking to be able to move back to Detroit.
Okay. I was going to explore that with you, Mr. Robinson. So home for you is Michigan.
Yes, sir.
Why were you in Georgia in September of 22?
Visiting family.
You have family here as well?
Not no longer.
They've left.
He moved to Arizona.
Okay. You will need to start out in Georgia when you're released. You're going to be on probation for a while, and that can be transferred to Michigan. It's a process. You need to fill out some paperwork, and Michigan needs to say, yes, we'll supervise Mr. Robinson, but it's not instantaneous. Do you have a place to stay in? It doesn't need to be in Atlanta, but it needs to be in Georgia. You're not allowed to leave the state until the transfer has been approved. Do you have a place to stay in Georgia? Okay. I guess you can talk with probation when you do get out about how quickly you can get back to Detroit. But just know that if they can't find you or you leave Georgia too soon, that would be violating your probation. And that's the wrong way to start that part of your sentence. So I'm not trying to complicate things for you, but it takes a little bit to transfer that supervision to the other state. They have to confirm that you've got a valid address, and I don't doubt that you do in Detroit, and then probation up there gets ready to receive you and you're good to go. It doesn't happen while you're in custody. You actually have to get out and do that kind of paperwork, okay?
Understand.
All right. Mr. Robinson, it is possible that you would need to come back to Georgia to testify if there is a trial in this case. You have an ability to make getting here complicated for the state because you'll be in Michigan. Are you telling me on the record that you will not resist a subpoena? If you are given a subpoena from Georgia, you could say, I'm in Michigan, I'm not in Georgia, so I'm going to ignore your subpoena. And then the state can come to me and I sign something, and a judge in Michigan signs something, and actually arrest you in Michigan and ship you down here. That's the hard way of doing it, but someone can tell me on the record, hey, if I get a subpoena from Georgia and it's about this case, I honor my commitments. I'm not going to fight that subpoena and say it's not valid in Michigan. Tell me what you're going to do. Should it happen, I don't know that it will, but should it happen that you get a subpoena to come back down here for this case? You'll honor the subpoena?
Yes, sir.
Okay, you understand that if you don't, then there's still a way to get you down here, but it's not the fun way, that they'll scoop you up, and when they can fly you down here, they will, but you'll basically be stuck in custody during that time. Do you understand?
Yes, sir.
Okay.
Your Honor, I did speak with, Mr. Robinson about speaking with the state prior, and he's gonna try to get that done in that time of probation transfer.
Sure, I'm going to leave that up to him, but that's a perfect thing to do to fill. It's not many days that you need to be here while the transfer's happening, but you will be in Georgia for a minute before you can go back to Michigan after they've accepted supervision there. And during that period will be an ideal time to take care of one of your obligations of your sentence. All right. Well, gentlemen, I find there's a factual basis for your pleas. This sounds like an awful situation. It's ending in a way that maybe no one would have forecast back when the indictment came out, but cases take circuitous routes to get to where they are. Mr. Abate, I don't know that anyone from Mr. Gassford is here. Have you received any information from his family that I ought to hear?
Other than they were fine with the recommendations that were made today to the court. Mr. Gaspard's mother and father are both very elderly and suffer from dementia as well as Alzheimer's. So they are speaking with them, and they understood what the recommendation was.
Okay, got it. All right, well, I find there's a factual basis for both pleas. Mr. Hardy, I find that your plea is knowing and voluntary. Knowing means you've understood the things we discussed. Voluntary means that no one's forcing you to enter this plea, that you're doing it only after you had a chance to think about it, consult with your lawyer, and it's your own personal decision. Do you agree with that? Mr. Robinson, same thing. I find that your plea is knowing and voluntary, meaning you've understood things and no one's forcing you to enter this plea. Do you agree with that? Okay. I'm sentencing both of you pursuant to the Probation Options Management Act. This will apply more to Mr. Hardy. I don't know how it will work in Michigan, but what it means is that while you're on probation, if you have a small problem on probation, if you miss a meeting with a probation officer, they might write you up, but that doesn't come back to me. You and probation work through that. If there's a bigger issue, you are arrested for anything, to include armed robbery in Mississippi, or drugs or domestic violence in Michigan, arrested for anything, that comes back to me. So you might be in a different place where you're arrested, but you'd be held there, brought back here, so we deal with the probation consequences of the arrest. Mr. Regis, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Bumpus?
Yes, Judge.
Mr. Abadi?
Yes, Your Honor.
Mr. Hardy, is it okay if someone in my office electronically signs your name to the indictment indicating your guilty plea to these reduced charges? Mr. Robinson? All right, we'll do that. So the structure of your case now, because the state has reduced the murder and felony murders to voluntary manslaughter, is that there'll be a sentence on count 1. Counts 2 and 3 are vacated. 4 and 5 merge into count 1, and then there'll be a sentence on counts 6 and 7. I don't do commuted to time served sentences or reduced to time served. Judges can't really commute things. But I have looked at how long you've been in. And so, Mr. Hardy, I'll start with you. Your sentence on count 1 is going to be 10 years to serve 2 years and 9 months. That's, I'll make sure I did the math right. That should be 33 months. The balance will be probated. Count 6 and 7 are the same sentences. So 10 years to serve 2 years and 9 months with the balance probated. Special condition of probation number 1 is that you provide truthful testimony if you are subpoenaed in this case and you don't resist the subpoena. Special condition number 2 is that within the first month of your release, you meet with the district attorney's office to have whatever conversation you're going to have, and that you otherwise cooperate in the prosecution of anyone else who remains charged or is recharged in connection with the death of Mr. Gassford. Mr. Robinson, your sentence as to count 1, based on these negotiations, is 10 years to serve 2 years and 6 months, 2 years and 6 months with the balance probated. And same sentence for counts 6 and 7. They'll run concurrently with each other. You served a little less time because you were up in Michigan, and that's when you got scooped up. So I don't think you were any less involved or you're any less culpable. But what was negotiated between the parties was a sentence that ought to get you released now. And that's 30 months. You've done a little more than 30 months. Which is 2 years and 6 months. You, as special conditions of your probation, will 1, testify truthfully if you're subpoenaed in the prosecution of anyone connected with the death of Mr. Gassford. 2, within 1 month of your release, you will meet with the district attorney's office to have a conversation with them. And 3, you will not resist or reject a subpoena from Georgia if you are living outside of Georgia when that subpoena to come to testify is delivered. Mr. Hardy, do you have any questions about anything we discussed? Mr. Robinson, any questions about anything we discussed? Okay, I want to be very clear. I don't think this sentence reflects the seriousness of what happened and what you were involved with, but cases don't always go the way that the evidence suggests they ought to go. And I respect very much the work your lawyers did in negotiating with the prosecutor and the situation in which the prosecutor found himself in terms of evidence he can use and can't use, et cetera. So I don't think this sentence is reflective of how serious things were, but sentences don't always match what happened. Do know that if we are together again while you are on probation and what you were involved with had anything to do with illegal drugs or a crime of violence, I will, assuming the state proves up the violation, and with probation revocations, their burden of proof is just a preponderance. I will be inclined to revoke every day, hour, minute, and second that I can. My hope is the long and undoubtedly unpleasant time you've had at Rice Street has moved you in a different direction, so that when you get out and get back to your communities, you're doing something different than what landed you in room 344 with Mr. Gassford in September of 22. Mr. Abadi, anything else on behalf of the state?
There you go.
Ms. Bumpus, anything on behalf of Mr. Robinson?
No, Your Honor.
Okay. Mr. Regis, anything on behalf of Mr. Hardy?
No, Your Honor.
Ms. Bumpus, I think you took this case when we were doing our C3 program, and it's one of the last ones left. I appreciate you sticking with it. You've had lots of twists and turns in your life since then, but you stayed with the case, and I appreciate that.
Thank you, Judge.
All right. That's it.
Thank you, Your Honor.
Judge,
Yes?
both defendants would be needing reporting instructions.
Right. One more thing. You guys need to get that. That's Ms. Simpson with probation. She's usually sitting in the jury box, which is how I remember. There's one more thing you need to hear, because you will be getting out, if not today, this weekend, at most Monday, and you're going to need to report to probation. So let me start with you, Mr. Hardy. Will you be living in Fulton County? You can live in any county you want. What county will you be living in?
I don't know. I'm not from here, so I don't really know. Like, I know around that way by Lennox Mall.
By what mall?
Fulton. Here, Lennox Mall.
Oh, Lennox Mall. That's the place where you'll be staying?
Yes, sir.
Okay, all right, so it sounds like one Fulton County, and we gotta give Mr. Robinson Fulton instructions because he doesn't have a fixed address at this time.
Correct. When regards to Mr. Robinson, he needs to make plans to remain in state for at least 45 days.
It doesn't necessarily take that long, but that's sort of worst case scenario. All right, and what are their reporting instructions, Ms. Simpson?
What is the zip code for Mr. Hardy?
I don't know that he knows that. He knows that he will be near Lennox Mall, so we're assuming Fulton County for now.
Okay, so both defendants would need to report within 48 hours of their release to the Atlanta Probation Office, and that's going to be 276 Memorial Drive, and that's Atlanta, Georgia 30303.
Do you guys need that written down? You know where that is? Yes, what?
Read down.
Okay.
I will email both counselors the reporting instruction sheet.
All right, I don't know if they're gonna see their clients anytime soon, so,
There's a family member that I'm sure.
so is a family member here now, or you could email it to a family member. Great. All right. You do the same?
Yes, Your Honor.
Okay, great. So perfect plan as usual, Ms. Simpson. Get it to the lawyers, they'll get it to family members who will make sure that Mr. Hardy and Mr. Robinson know where they need to be and when. Don't miss your report date, okay?
Yes, Judge, thank you.
You're welcome. All right, Ms. Harvey, we are good to go. You are free to go. What we've got left today, we're not going to need pretrial, so thank you so much.
Okay, thank you, Judge. Have a good day.
Oh, we may. Oh, don't leave, Ms. Harvey. False alarm. Oop, she dropped off. We'll get her back on.
You say?
So, how long will they be breaking? So if we could do it at 1 o'clock, we can do it at 1.
Oh, at one?
I'm not gonna be here at 12:30.
Okay, so like, we could do it from, like, if she's bringing.
If she's bringing for an hour,
It could be that.
yeah,
Okay, I'll switch the time.
okay,
It'll be, she's gonna take an hour, right? She'll have at least 1:30. So
Okay. So 1 o'clock, we'll do Mr. Lemons.
I see, I think.
Yeah, just this will result in, this is just, there's no other conditions, he's free and clear after this.
So I wanna know,
18 months, starting from the,
why don't we talk about what's happening, and then if people need more time, I can let you know what the schedule looks like. So let's get everyone out here and we'll make a plan.
That's it, okay.
All right, Mr. Slayton, good morning. Tell me what the plan is with Mr. Thomas.
so I believe we'd be in this Davis here kind of agreement, we'd like to complete today.
Okay,
The offer on the table was 15 months, starting from the incident date, which is July 3rd, 2024, which my math is correct, puts him at September 3rd release date. Right now, he's set to be released from the Department of Corrections on August 27th or 28th.
okay.
But
This is whatever the terms are, which we can get on the record, it's a negotiated plea.
Correct. I
Okay,
believe that date's June, right? Is it June or July?
June 3rd.
we'll get it in the record. I mean, all that stuff is there. Any reason we shouldn't proceed with that now?
Yeah, just this will result in, this is just, there's no other conditions, he's free and clear after this.
So I want to know whether we should go forward with the plea right now. I don't know if he's got other cases. I don't know if he's got things in other counties. We can talk about all that. I just wasn't sure if you needed more time to talk with Mr. Thomas, or if we could start the plea hearing, during which we'll talk about free and clear, what was the date, credit, et cetera.
Yeah, we are ready.
Ready? Great. Then let's do that. Mr. Thomas, are you able to stand, or is it better for you to sit?
Sit.
Okay. If you guys could move that microphone around, and we got to move the camera a little bit. Well, I think we may be all right. Let me add that. I just want to make sure that that'll work. Perfect. Ms. Rivers is able to see you, and we'll do that. Okay, good. Then let's get on the record in 24 SC 005283, which is State versus Thomas. Mr. Thomas is here in court with his lawyer, Mr. Slayton. We have Ms. Davis for the state, and it's my understanding, Mr. Thomas, that you're prepared to enter a plea in your case. Is that correct? All right. Ms. Davis is going to put you under oath, ask you some questions. You need to answer those truthfully. I may have a few questions.
All right, we have our jurors back, counsel and parties present, and we had just finished with the opening argument from the state. Ms. Watt, are you prepared to proceed with opening argument on behalf of the defendant?
Yes, Your Honor.
Actually, I think I said closing argument. Go
Yes.
ahead. Go ahead.
May it please the court, counsel, ladies and gentlemen of the jury. I hope it surprises no one, since I've been doing it consistently, but I will talk less. And I would hope that nobody will judge the strength or weakness of the case just because I say fewer words. I want to go through some of the testimony that we heard and some of the things to take away from it in our view. Detective Fangman, I agree with the state that his video is important because it shows us some things. It shows us the layout of this home. And no, we're not obsessed about this demonstrative exhibit. It's just wrong. Because the state spent a lot of time talking about how Houston would have had to sneak through this hallway that's right next to the bedroom door, so somebody would have had to hear him. That's why it matters that that is misleading, because it's a whole room. And there was more room for him to go through that unnoticed. We also see ransom on video. And Anything I say, you should always defer to your own recollection, of course, and your own notes and what you heard in the evidence. No attempts to mislead from either side. We see Ransom on that video when Detective Fangman walks in. He's just laying there on the floor in the middle of the living room. And when he sees the officer, he gets up. There's been a lot of talk or speculation that Ransom had to have been barking at somebody. He had to have attacked somebody. But it doesn't appear to be the case if he's literally laying on the floor as Karina is screaming bloody murder. And even with what's going on with the children and with Ryan, he remains laying on the living room floor. A little nitpicky, but we did hear from, I think it was Gladfelter, that the wallet that was on the end table, it was never moved, as if he would know that. If you watch the video, there's no wallet on the end table. The video also shows the movements of the EMS personnel. And that's kind of important because we link it to Ken Martin's testimony, and we see on the video that EMS steps behind the chair to get to Ryan and goes around so they don't step in the blood. That's why we don't have their footprints. It's not because that entire pool is dry, it's because they don't step in it. The video is also important because it shows the state of Karina, and it is your job to decide the credibility and whether this is hysteria or whether this is true panic. We heard from Cade Cooper that Ransom was a normal dog, which is consistent with what we see on Fangman's video. We heard that his room had been newly remodeled. We didn't hear anything that made it appear like he was suspicious of being told to sleep in his room. He said he woke up to his mom screaming. This is interesting because everyone is saying how loud this had to have been. These gunshots had to be so loud, and there were 2 of them. But nobody testifies to having heard a gunshot. Cade confirms that his mom is running back and forth between the bedroom and the living room. We don't know exactly what time Cade got up, of course, in this minutes of span of when Karina is making all these steps. We have our only basis of a timeline is the fact that we know there must have been enough time for him to go and slip and leave footprints behind. But he confirms that his mom was running all over the place, freaking out. Cade didn't make it sound like Ryan and Karina fought a whole lot. We've heard testimony from some of the friends that Karina would be pretty mean sometimes. We didn't hear from Cade that they spent all their time arguing, though. Also didn't hear any conflicting testimony from Cade about the sleeping habits of his dad, or whether he actually does or doesn't get up in the middle of the night. Andrew Gladfelter, we see the pictures that they take. We see this showcasing that is left by the front door. Cannot tell by looking at Detective Fangman's video or any body cam, cannot tell whether that showcasing is visible on that floor at that time. It is certainly possible that somebody kicked it to get it to that final place. Or it's possible that's just where it landed, certainly. But we also know from the pictures that there is a vent nearby. And we know from the pictures that these things are small. And Andrew Gladfelter did testify that they didn't look within the ductwork to find those things. If you ever drop something down a vent, sometimes it goes further than just the very top. The photos do confirm that this house was in a state of remodeling. He tells us that at least this front door was locked. And a point on the locked doors, this is the country, right? This isn't Cedar Rapids. This is the country. This is rural country. A lot of people don't lock their doors at night. Aaron Cooper couldn't tell us whether Ryan and Karina normally lock their doors. The state wants to contend that this is such a secure place because of the existence of keypads. But nobody has confirmed, yes, they always lock their doors. They did appear to have keypads in places where all the toys were housed. Tiffany Lord, she testified that there are millions of artifacts on these phones. Millions. That's a lot. There are a lot of data points on phones. You saw a handful. You saw some gaps in search history. She picked out one. There were others. We saw some Google searches that Houston made. The best she could find for Karina is a hunter education course. She can't explain the gaps in the Snapchat messages because in Defendant's Exhibit A alone, we know it's just not possible. These are all the snaps between these two people. And when she was testifying, I put up on the screen the series of Biome app intents that she did later testify about yesterday. There's a lot of messages happening, a lot. And she can't tell us why we get messages, let's say June 13th, why those are able to be retrieved, but then there's missing ones in the middle. She can't answer that. She can't say it's because these were deleted specifically. She can't say because whether it was Snapchat that did it on its own, and that's because Snapchat, that type of software is proprietary. And that's what Chris Lyon was kind of explaining. It's because Apple doesn't want you to be able to get into the person's phone. Facebook wants to pretend their stuff is encrypted. These applications don't want to help police get into phones. And so that's what he was saying when police, it's essentially a hack. This software is them kind of getting them through the back door and being able to expose some information. But they can't figure everything out. So that's why we don't know why we have messages June 13th and then nothing until June 17th, and then seemingly a gap in the conversation leading into June 18th. We did ask her, can you explain why some of these numbers look sequential for the Snapchat? She didn't know. She didn't say that they're not. She didn't say that we're wrong about reading the way we're reading a database. She also came back and testified yesterday that there's a Biome app intent at 4:20 in the morning. But there's no message there, and you cannot answer how that's data loss. That is simply data loss. That's what it is. This might be hard to see, but this is Defendant Exhibit J, I believe. No. It's in any event. Look at the middle. Those numbers are going in order. That's what Chris Lyon meant when he said, I know how to read a database. I have training in a database. Because you can also use your common sense to interpret information. Those numbers are in order. Otherwise, I guess it's just a coincidence that all those numbers are in order. And obviously, above the blue line, we have a gap in the numbers because there's a gap in time, and there are other messages in between that time that don't get retrieved. The state asked Chris Lyon, and Chris Lyon I think volunteered, that basically the data gets retrieved off the phone. And then what happens is we use this software to be able to review the data on the phone. Because otherwise you have a bunch of raw data. And Chris Lyon said he did not compare this information on the software to the raw data. That's what he means when he says he didn't test it. I could be wrong. I never heard Tiffany Lord say she tested the phone raw data against the information she was providing to either. Coming up here and saying it's impossible and sounding confident doing it doesn't mean you're right. We heard from Carmen, I think it's Earhart, and Kirsty Shetta. They never saw Karina be physically violent to Ryan. I think it was Carmen who testified about Karina leaving some groups, kind of a tangential point, but we did hear from Holly Witt that she was still in this group that Carmen is describing. You can also surmise that you could confirm that that is true, because on defendant's exhibit with the Snapchat picture, you see somebody talking about being in Dallas. And who do we know is in Dallas? The state also talks about how everybody is like covering their location and everything and taking all these efforts to conceal a crime. We have lots of data points for Karina's geolocation from Snapchat. We only have a couple for Houston. I submit to you that that's because her location is on. People come and testify now after the fact with this information, and they're looking at Karina and her behavior through a different lens. They were her friends. And it's easy to look back sometimes and be like, gosh, this must have meant that, gosh, this must have meant that. That's just you trying to answer questions in your own head. I say the same of Teresa McBride and Brian Morrison, because Teresa McBride even testified to it, that she has gone back over time and tried to figure out what she missed. And that's why we have, them coming years later and telling the police one time in either 2018 or 2020, she said she would shoot him in the face. She had testified at her deposition. She was asked about that the behavior she saw between Ryan and Karina was nothing outside the norm of what couples do. She testified before you that Karina is probably just harsher than Teresa may be, but it wasn't something that appeared to give her much concern at the time. It's clear that both Teresa and Brian did love both these people. We heard some talk from Brian about statements about documents. Unclear what that was necessarily about from the testimony, but it certainly was nothing like, if something happens to me, look to Karina. It could have been just a reasonable discussion between two friends. I mean, it's reasonable to think somebody would tell their friends where their stuff is in case of an accident or something. Brad Rund and Jeff Gudenkoff gave us some information. Brad said she overdrafted, and she did overdraft a lot. Jeff Gudenkoff, he showed us the policies. They were gotten in, I believe, 2013, and didn't hear any evidence that at any point Ryan Cooper attempted to change the beneficiary. Ken Martin, he was on the stand for quite a while. He had a lot to say, and we learned a lot about blood spatter. And he agrees that Fangman's video is important because that's the closest we're going to get to the pristine scene. Okay? What's also important in that is you can see, and I think there was a screenshot provided of it, you can see that Karina is on top of Ryan. The state has continuously argued that she's rubbing her face all over him. That's not apparent to be the case on any of these videos. That is suggestion by the state. Ken Martin described it more as she was on him embracing him. What is noteworthy is that she has no blood on her legs or her feet. The way that Ken Martin testified would suggest that if she was nearby when Ryan gets shot, she's going to have spatter on her. If she's hanging around looking for shell casings, she's going to have spatter on her. That blood spatter went everywhere. And he said that the blood spatter in the pool could have formed very quickly. The state wants to say it was some time. It's unclear what timeline they want to have here, because making it sound like the murder must have happened at 4:23 because that's when she's up and around. But then what takes Houston 50 minutes to get there? In any event, what we know from Ken Martin is that blood can pool the way that we see here, either very quickly or very slowly. It can dry either very quickly or very slowly, depending on all the environmental factors and air and humidity. Based on his testimony, it appears to be possible that Houston would have time to come in, shoot Ryan twice in the face, get blood spatter on his shoe, leave his shoe print as exiting the front door. Everybody agrees that's Houston's footprint. It's his shoe print. I apologize. It's his shoe print in that house. That's Houston's. The footprint, the bare footprints, we can't match because of insufficient quality of the photographs. So we don't know whether those are Kate's footprints. Ken Martin also testified, we understand that Ryan would have been in one position for what I'll call the first pool to form, and then he had to have been shifted. But he also testified that can be involuntarily done by Ryan's own self. This is a picture of Karina that was taken by law enforcement, and you can see you have them in your evidence. There's no blood on her, aside from where she had contact with Ryan by being on his lap. We know that Houston must have probably had blood on him because he's got it on his shoes. And enough that there were also droplets on the steps. So there was enough blood on him that not only is he leaving a shoe print, he's leaving drops. Just running through the remaining witnesses that we have and what we learned. We learned that Houston attempted to give the police the wrong gun in 2023. We know that the police find shoes matching the bloody shoe prints at the scene at Houston Danker's house. And we know Houston had the murder weapon. So as in the opening, Houston Danker did this, and we know it. Special Agent Holly Witt. She does a lot of work with the cell phone tower data. We know that Houston is driving by Karina's house while Karina's not even there. We know that he's lingering around her house for a span of minutes. We have nothing to suggest that they saw each other. There's perhaps been some confusion about whether both of them have Snapchat activity happening while he's near her house. We submit to you that the slide showed that Karina had Snapchat activity, or at least geolocations updating at that time. But Houston did not. Houston's only data points were at his house, and I believe there were only a couple of them for his geolocation updating. So what is he doing lingering around this house? He could be planning his attack. He could be checking whether a door is unlocked. Also, begs the question, was he stalking her house other days? Was this a regular occurrence? Holly Witt would be able to figure that out. We heard from Karina. You are going to have to decide her credibility. She got up here and she sat and she told you what happened. She sat through the state rubbing her nose in what she had said. She did it. She told you what she knows. And she would submit to you, she attempted to do her very best to, if she said something wrong, make a correction and correct herself. Her testimony does make sense. She does give information to the police. Not all of the information, but she does give them information. She tried to get to the gun safe because somebody was possibly there. An officer was able to open it with his thumbprint. I don't know how that happened either, I guess, how his thumbprint is able to do it, but it's unclear how the state is taking the position that she's saying things that only help her, but also saying that she's only saying things that don't make sense. Her testimony was also that she sees this clotting after the 911 call. But she's older. She couldn't have been manipulated by Houston because she's older. That's a very bare bones way to look at something, but it's certainly not impossible that a younger man could engage in this emotional affair with Karina and be participating in the way that we are submitting to you. Nobody's claiming Houston is a genius, but we are saying he's manipulative. People Houston's age commit crimes all the time, and very serious ones, without the aid of an older person. Well, she got upset on cross. It's a tough spot to be. It's a tough spot to be, being dragged through every single thing that you said, having bits and pieces of your phone information displayed for everyone to see, and you just being dragged through it over and over. But she lied for so long. She told us why. She felt like Houston was possibly setting her up. She felt like people were accusing her. She was scared nobody would believe her. It was wrong and not helpful to lie for so long. But she explained it to you. But the Snapchats. Again, it's incomplete information. It's obviously incomplete information. And that means data loss. Phone dumps are not gospel. There's a jump in the message ID sequence. I submit to you to use your common sense about what that could indicate. Tiffany Lord is so sure about how this biome works at 421, but again, there's no message, and she doesn't have an explanation for that. It seems like Tiffany Lord is able to explain things when they're helpful for the state, but doesn't understand them when they could be helpful to the defense. We don't have any Snapchats saying, please kill my husband. We don't have any Snapchats saying, please be quiet when you kill him. We don't have any Snapchats that the state seems to think she's busy making sure everybody is subdued. That she says, okay, he's asleep, everybody's asleep, time to come over. And then by the apparent timeline the state is establishing today, show up 50 minutes later, and we're still going to know that everybody's asleep. The state says that this had to have taken place at home with the children present because it would be weird if the kids were just not home that night. Sure, but why does it have to take place at home? If you want to kill your husband, there's a lot of places you could do it. It wouldn't involve putting your children through this. Also, if you plan to shoot your husband with your children home, You have to expect they could wake up. If you have kids, you know they wake up sometimes. I don't know what subdued means when the state says that, but there's certainly been no suggestion that anybody was drugged here. No testimony of that. And instruction number 10, that is about how you can use statements of Karina. You can use her statements that she made earlier, you can use the statements that she made here, and you can use them to decide if you believe her. You can disregard all of her testimony if you want to, but you don't have to. And the instruction says, do not disregard Karina Cooper's testimony if other evidence supports it, or if you believe it for any other reason. She got up here and she said that she was scared of Houston. And the state has tried to mishmash the timeline there. She wasn't scared of Houston until he actually killed her husband. She's still engaging in this ridiculous online emotional affair fantasy world until he actually does it and kills her husband. Then she's scared. And is that a ridiculous notion? Perhaps to some of you. But it was real to her. And she was scared. Whether it's because she thought that he was going to harm her, or whether it's because she thought she'd go down with this ship. Do not disregard her testimony if you believe it for any reason. Houston Danker. There's a wealth of evidence against Houston Danker being responsible. Houston Danker, we're going to say he's only so old, then he's probably reckless in his planning. He doesn't care if there's going to be a confrontation. He had made all these types of statements before. Why does he choose this night to do it? Nobody knows. He didn't testify. We know he's slinking around the house. We know he's familiar with the house. Cade told us Houston had come over and sat on the patio and drank. It's not like he needs a guide through the house. Presumably, Karina would have told Houston at some point that Ryan sleeps in the recliner chair, since there are messages of them fighting about Karina spending time with her own husband. Karina told you that they had been arguing earlier in the night. That could explain why this guy is driving by and slinking around, and it's because he's nuts. He was, up until the time he actually killed her husband, just a blowhard. Known for being a blowhard. Telling tall tales might have been the words used. So, when he is frequently saying to Karina, hey, by the way, I forget what her example was. There might be a bomb in the vehicle or something like that. Or, by the way, when I shoot him, make sure you pick up the shell casings on previous occasions in the past, and then nothing happens. She doesn't think anything is going to happen this time either. And when it does, then it's real. We talked about in jury selection, presuming somebody innocent. And that we're required to do so. We're required to look at things different in a courtroom than we might look at them every day or in our everyday lives. She is presumed innocent unless and until the state proves her guilty with evidence beyond a reasonable doubt. And it doesn't matter that she's sitting at this table with me. It doesn't matter that she was arrested. What matters is the evidence. Beyond a reasonable doubt, you have an instruction explaining that to you as well. Like we talked about in jury selection, it is not a gut feeling. It is not a snap judgment. It is not even, I'm pretty sure. Benjamin Franklin said, it is better that 100 guilty persons should escape than one innocent person should suffer. And that's what we mean when we say beyond a reasonable doubt. We want jurors to be firmly convinced of somebody's guilt before they make that decision. If there's any part of you that is feeling doubt, reasonable doubt, don't convict her, even if you're pretty sure, because that's not firmly convinced. Aiding and abetting. State's case is just words. There's no proof that she lifted a finger to help Houston. The state makes assertions about the things that she probably or could have done to help Houston, but there is no affirmative evidence of that. We do not convict people of the most gravest of crimes based on thoughts or words. It doesn't matter if she sometimes had made statements about wanting a rogue semi-accident, which, I would point out, Tiffany Lord conveniently leaves out of her Snapchat or her PowerPoint, the very next statement being, I have dark and twisted minds sometimes, divorce me. Cherry-picking evidence is misleading. And it's okay if you think you wanted to see all of it. You weren't given all of it. Houston Danker on this evening went rogue, and he actually did it. The aiding and abetting instruction tells you that her mere knowledge of the crime is not enough. The fact that she knew, or had every reason to believe he actually went through with it this time, and didn't tell the police that doesn't make her guilty. The bottom line here is that no one ran off into the mountains. Karina did not blow through the insurance money. We can sit there and quibble over how much she spent on this and how much she spent on that. It had been a couple of years. She's not making any income from her job. She's got 3 children that she's paying for, presumably rent places. You're going to go through some money. Nobody testified that she went and got a designer bag or took a lavish trip or started attending the spa every couple weeks. Nobody said that. Nobody testified to any indication of a continued relationship between Karina and Houston. So if this was their grand plan, to kill Ryan, get him out of the way, and ride off into the sunset, why does it end? It ends because it became real and he actually killed her husband. Karina doesn't have blood on her legs and feet she would have had to have. No one has testified or even hinted at the fact that she was a bad mother. I submit to you that is important because no mother would do this with their children home. No good mother. There were 100 other ways that this could have gone down if it was planned and meant to happen by Karina Cooper. She never would have done that with her children home. She never would have put them in a situation where her son is slipping in his dad's blood. She never. And nobody has said that she would have. She did not have any specific intent to kill her husband. She did engage in reckless behavior and talking to Houston and not cutting it off and having all these conversations. It was reckless. But she didn't have any intent to kill him or for him to actually wind up dead. She wasn't even actually going to leave him. She's getting attention from some knucklehead on Snapchat, and she likes it. And she's living in a fantasy and a dream world until he does it. This decision you're about to make is a decision like no other.
Judge, I'm going to object. May we approach? You may.
This is a decision like no other that you will make. When you buy a car, for example, you decide you don't like the car, you can sell it. Even the decision to get married, the decision to do lots of things in your life can be changed down the road. The decision of whether or not the state has proven somebody guilty of murder with evidence beyond a reasonable doubt, you cannot take back. So you better be sure. Please carefully consider all of the evidence that you heard in this case. I know we've heard the word Snapchat about 5,000 times, but there's a bigger picture here, and there is a woman sitting here accused of killing her husband. She didn't do it. She wouldn't do that. She would not do that to her children. She may be an idiot in her relationship with Houston, but she didn't participate in the murder of her husband. Please think it through. Find her not guilty. Thank you.
Mr. Engel, rebuttal?
Thank you, Judge.
And you got to move the podium a little again.
Yes, let's think it through. There's no evidence that their grand plan came to fruition. Nobody rode off into the sunset. And that's supposed to be evidence that Karina didn't participate in the murder. Actually, quite the opposite. Why? Why didn't they ride off into the sunset together? Because people figured this out pretty quickly. They thought they were smarter than everyone. They thought people wouldn't figure it out. They even worked out stories ahead of time if they were questioned, because they did it together. Let's think it through. Day after the murder, only hours later, Karina Cooper was interviewed. Probably a bit of a surprise to her. Ryan Herman leans forward and says, "What can you tell me about your relationship with Houston?" Didn't anticipate that. Thought they did a better job. Figured out pretty quickly, maybe he has something to do with it. She's surprised and shocked. Baker? And then, later that day, Houston Danker, 3, 4 o'clock in the afternoon, was brought in for an interview with Agent Trent Bilodeau. What's interesting about those interviews, either of them could have said anything about their relationship with one another. How do we know they're working together? They said the exact same things. Watch the videos. Said the exact same things. Why? Because they planned this. They both said they were friends. Tell me about your relationship with Houston. Danker? He's my friend. Houston Danker. I'm like her gay best friend. They agreed, we'll go with friends. How do you know him? She cut my hair. Karina says, I cut his hair. Houston says, she cut my hair. What else do they say? Well, we're friends on Snapchat, but just like nothing inappropriate ever. They both say that. Admitting to things that based on their research, they know probably will be figured out. Now they think they've done a good job of deleting everything. They certainly think they've done a good job of deleting the most incriminating snaps. 2,400 messages recovered on Karina's phone, Snapchats. 61 of them deleted. Those 61 include the night of the murder. So, they also came up with a story. Because they know that people in the community have suspected that they're having an affair. So they both told the police the exact same story. They could have said anything. They said the exact same thing because they're working together. What did Karina say? I babysat his kids, so his truck was in my driveway. So people assumed we were fooling around this stupid town and their rumors. What did Houston say? She babysat my kids. And so my truck was in her driveway. People assumed I was having sex with her. Nothing like that ever happened. They told the exact same story. They told the exact same story because they're working together. They could have said anything. So they didn't run off to the mountains together because the police were onto them very quickly. And a lot of what they did was pretty stupid and pretty easily discovered. But they were at least smart enough to stop communicating via Snapchat or in other ways that they could be detected after the murder. Is it a surprise that they decided to cool it? Having committed a murder together, that they finally figured out, oh wow, these investigators know a lot of stuff, and they know it really quickly. Maybe we're not as smart as we think we are. Maybe we should stop. It's not surprising. It's actually evidence. What they said and what they did, that they were working together, and the fact that they stopped communicating is further evidence of their guilt. Defense talked to you about the concept of cherry-picked evidence, and they said, you didn't see everything. Defense has access to all the evidence. They can show you whatever they want. And they're trying to claim that the state is somehow hiding something. Nothing to stop them from showing it to you. They didn't show you anything because there isn't anything. We heard a lot of information about Houston Danker and his threats and the fantasy world that Karina was living in, the fun fantasy, as any mother of three would have, happily married, where, you just talk online with your affair partner about murdering your husband. It's a fantasy world. It's just fun. Makes no sense. It's ridiculous. It's not a fantasy, it's real. She knows it's real. She told you, Karina, when she came up and testified, she was in a tough spot. Yeah, she's in a tough spot because she murdered her husband and she got caught. So yeah, it's tough to sit up there and try to talk around all the evidence. And that's why so much of what she said was completely inconsistent and insulting. It makes no sense. Defense talked to you about the fact that, Karina was so scared, there's the threats, she's worried about being set up. They told you, don't disregard Karina's testimony if it's supported by other evidence. Where's the evidence? There isn't any. They have access to everything. Karina's had a phone, presumably, throughout this entire period of time that she's being threatened. She told you, he's threatening me, he's threatening my friends. She's afraid. I'm afraid that no one will believe me if I talked to the police about what happened. Okay, if that's true. Screenshot? Save any of those messages? Save any evidence? There's nothing to stop her from doing it. Nothing to stop defense from presenting it to you. There's none of that because it's not real. Because it didn't happen. That's the fantasy. That she was somehow subject to these threats and manipulation. Read the Snapchats. Any threats? Any manipulation? No. It's, I hate Ryan. I hope he dies. Who's saying that? Houston? Is Houston the one that's saying that he hates Ryan, wants him to die? What's Karina? Look at the messages. It's Karina. Karina's friends. Karina made death threats. Karina Cooper said, I'll shoot you in the face. Look at the messages. Is it Houston? It's Karina. Talked again about ransom. I told you, and the evidence supports the fact, that when that dog is around Karina, he's completely subdued. Defense just told you. Look at the video. He's laying down, he's completely subdued. No reason to believe that that dog is scary at all. Unfortunately, Karina, talking to Ryan Herman, said he's very protective. And she explained how and why. So Karina's words. Defense is trying to convince you that Karina was not looking for shell casings because there was a vent nearby. Much like all the other coincidences that apparently occurred on the night of the murder that just sort of look bad for Karina, apparently one of those shell casings just happened to maybe possibly land exactly parallel with the slats in the vent that was covered at the time of the murder and somehow fell through there. We've heard no testimony that they actually fit through there. This is something that the defense is telling you. There's no evidence to support it. Defense talked to you about the fact that they didn't find a lot of stuff in Karina's search history, so therefore she didn't do anything. It just means she did a better job of deleting her stuff than Houston did. Defense pointed out the fact that, hey, there were some other gaps in her search history. Yeah, 2 weeks here and there. But the gap that Tiffany Lord referenced, again, just one of those coincidences. She told you, Karina told you, hey, something about, when asked about private browsers, I don't know how they work. I don't really get it. She doesn't really understand. But 5-month gap in her search history. 5 months. The 5 months that she was planning this murder. Right up to the murder. There's no other 5-month gap in evidence. It's another one of those coincidences. Of course, there's an easier explanation, which is the fact that she was planning a murder, the murder of her husband, with Houston Tanker. That's what was really happening. Defense also talked to you about the fact that Karina's location information was on. So, yeah, she's not trying to hide anything. They did the research. Again, they knew a little bit. what difference does it make to her when her part of the murder is to be at the scene if her location data is on? In fact, wouldn't that provide a convenient alibi? I'm home. I'm just home. I wasn't doing anything. Of course. Who cares? Karina knows that doesn't matter. Why does it matter if her location data is on? It doesn't. It's just going to show she's at her house, which she was, participating in the murder. Defense is telling you these things as though they're important. They don't change anything, and they don't mean anything. We're going to talk about the blood. We've had a lot of conversation about fantasy, dreams. We're going to talk about reality. We're going to talk about the forensic evidence. We've heard enough about the snaps. You guys know what they say. Let's talk about the forensic evidence. Let's talk about what Ken Martin said. Defense talked to you about Karina and the fact she didn't have any blood on her. Well, who controlled the scene? Karina did. How long was Karina up and around and awake? Quite a while. When did the murder happen? The state never said, and there's no evidence to say necessarily, as defense said, it had to happen 50 minutes later. That'd be consistent with one of the timelines that Karina gave. We saw Houston Danker's test drives, how long he could get back and forth between his house and the Cooper residence, so that they could figure out how much time they needed to delay things, so he could get home and open his fake snap message that she sent, because they think that'll trigger location data helpful to them. Send me something so I can open it when I get home. Deal? Deal. That's what they're doing. He's checking out how long it takes to get home. They're trying to manipulate location data. Karina controls the scene. They said Karina had no blood on her. They said, look at the pictures. Let's talk about it. You want the screen? Yeah. All right. There's no evidence Karina's looking for shell casings. Let's start there. Let's talk about the physical evidence. There's enough evidence in the snaps for you to convict Karina Cooper of murder in the first degree. You can ignore all of it. Let's just take a look at the scene. Was she involved? We already talked about the ridiculous notion that Houston Danker came over with a .22 rifle, sneaking through the house. And just as a side note, defense thinks it's important to point out, hey, that hallway there's a little bit wider. Watch the body cam. Doesn't matter if it's a room or a hallway. You can see on the body cam, there's 2 doors, there's Cades, there's a dog. You guys get it. Karina's looking for shell casings. Remember those casings. It's her job. Remember those. No ifs, ands, or buts. Phone manipulation, phone's going down. I love you too so much. What do we see here? Fangman's body cam video. What is on the arm of Ryan's recliner? It's Karina Cooper's cell phone. We heard that. The flashlight is on. Why is the flashlight on? Because she's looking for shell casings. That's why. She found one. She didn't find the other. There's things you learn when you kill somebody she didn't know before. One of the things that you learn, that scientists know, that detectives know, that investigators know, it's not like TV. You don't shoot somebody and they just lay gently back in their chair. It is chaotic. It is messy. And as smart as they thought they were, that didn't occur to them. They shoot Ryan. The plan is for Houston to get out of there as fast as possible out that door, which is exactly what happened. Karina's job is to find shell casings. Problem. It's chaotic as hell. She uses her cell phone flashlight to search around. She finds one, she doesn't find the other. It's on the other side of the blood pool. It's by the base of the door. She didn't see it. So there's a lot going on. That's why her flashlight's on. That's what she's doing. She's looking for shell casings. That's her job. Remember those shell casings. Remember those. Karina was present when Ryan was shot. How do we know that? Karina testified that she shook Ryan's foot. Heard her say that? She said it when she talked to Agent Herman. She said it on the stand yesterday. Ken Martin, blood swipe pattern, Ryan's right foot. Why does she have blood on her hand before she climbs on top of him? I ran out and I saw him. She says eventually she climbs on top of him and then she got blood on her. There's already blood on his foot, a swipe pattern. How'd that happen? Because she already had blood on her hands. Further evidence that Karina was present when Ryan was shot. You remember the blood pools. We're going to talk about what Ken Martin said. There's two of them. Why? The body was in two different positions. Blood pool number 1, which is the one that Cade slipped in. This is the pool that formed first. It is a drip pattern with satellite stains. What does that mean? It means after Ryan was shot in the face twice by Karina Cooper and Houston Danker, his body fell to the left. His arms were at his sides. Blood is streaming out of his face. That blood is dripping into a pool, causing splashing, which Ken Martin calls satellite stains. You see those satellite stains all around that blood pool. Blood pool number 1. Ryan's face dripping down into the blood pool for a fixed period of time, because eventually he stops bleeding into that pool when his body returns to an upright position, sitting in the recliner. There are no splashes or satellite stains associated with blood pool number 2, which you see at the base of the recliner. There were flow patterns that came straight down from Ryan Cooper into that pool that you can see right next to the recliner. 2 separate blood pools. That serves as a timing mechanism. That tells us a lot. That tells us that Karina Cooper was present when Ryan Cooper was shot. You already know this. You know this from the other evidence that's been presented. Let's start with Cade's footprints. We'll just get that eliminated right away. These are the slip patterns from Cade slipping in the blood. Were those slip patterns created before Ryan was in the upright position or after? After. How do we know? Because Ryan is no longer feeding that blood pool with splashes from his face. That's why the floor is visible. That's why it's not filled in. If he was still bleeding into that blood pool, you would not see the floor. It would be filled in. Or you would see satellite stains in that slip. Those little splashes with the tails. There aren't any. So when Cade slipped in the blood, Ryan was sitting upright.
Your Honor, I'm going to object.
Thank you, Judge. Keep in mind what I refer to as blood pool number 2 at the base of the recliner. That comes from a flow pattern. There are not satellite stains or splashes associated with it because the blood flowed straight down. It was not over a surface and suspended with dripping. So you won't see those splashes based on that. What do we see here? Remember what Ken Martin told you. Remember the timing. I just told you those splashes give us a timing mechanism because we have 2 separate body positions. What do we see in this image? You think they did it together? If you look at the bottom, the green triangle, Houston Danker's footwear impression. If you look at the blue rectangle, Houston Danker's footwear impression. Right there with it, what the state submits is Karina Cooper's footprint. You think they did it together? What do we know about when this footprint was formed? What do we know about when the footwear impression was formed? What did Ken Martin tell you? You can see the satellite stains. You can see the splashes. No voids or impressions in the blood pool. You can see the voids from Cade's. He said that means that those footprints and footwear impressions were formed almost immediately after the shots. That blood that formed those 2 footwear impressions, the footprint and the footwear impression, that blood came from the pool with the satellite stains, blood pool number 1. That means those were formed when Ryan Cooper's body was in position number 1, off to the left, filling the blood pool with blood from his face. The voids that would have been created by those have been filled in by the continued dripping. And you can see satellite stains because the dripping was still occurring. It's not Cade's footprint. You can see Cade's footprint. It's slipped in the blood. It left a void. It left a void because the dripping was over. Ryan's body was upright, forming blood pool number 2. The blood that made these came from his face when he was leaned to the left. It's not Cade's, it's Karina's. What else did he say? No evidence of him outside the door. They shot Ryan. Houston's leaving. Karina goes to the door with him, sees him off, and then closes the door. We know about the position of the door. Once again, when you kill someone, you learn things that you didn't know before. The blood tells the story. Ryan's shot. Ryan's leaning to the left. They head to the door together. Houston's got the gun. That's part of the plan. They don't know this.
But when the door was closed, there's something called high-velocity blood spatter that hit the door. And someone like Ken Martin, who's a scientist, can tell you that's from a gunshot. So we know the door was closed at the time of the gunshot. Karina didn't know you could figure that stuff out. She doesn't know how blood works. They thought they had the perfect plan. She doesn't know about drip patterns. She doesn't know about satellite stains. She doesn't know that Ken Martin and science can tell you that her footprint and Houston's footwear impression were in the swing area of that door while Ryan's body was still to the left before his body returned to the upright position, but it can. We've heard a lot about Snapchat messages, data loss, fantasy worlds. This is reality. This is science. Reality says Karina walked over to that door before Ryan's body returned to the upright position with Houston Danker. The door was shut during the shooting, opened it. Ryan's face is still dripping, creating satellite stains. How do we know that? Remember that picture of the door? Remember the edge of that door? Splashes of blood, because the door is hanging open while Ryan is hanging to the left, dripping blood from his face. Then she closes the door, and there's more satellite stains on the front of that door from the drip of blood from his face over and over and over again. She's there. She's absolutely there. Science says she's there. The fantasy world stuff, the snaps, it doesn't matter. She's guilty based on this alone. But there's more. Did she pull the trigger or did she not? You don't have to find that she did. She clearly aided and abetted in this crime. The evidence shows she shot Ryan Cooper in the face. How do we know that? Ken Martin showed you this video. .22 caliber bullet, right? Into a bloody sponge. That's called backspatter. See all the blood coming back towards the shooter? It's things you learn when you kill somebody you didn't know before. Karina Cooper is concealing backspatter. Now, defense wanted to tell you, hey, she didn't have any blood on her. We're going to talk about that. Let's think about, as defense wanted you to think this through. So let's think it through. What did Dr. Kelly Cruz tell you about the path of the wounds in this case? Into Ryan's face, to his brain, upward. Upward. The path of travel of the bullets was upward. Why does that matter? Well, Ryan was sitting in a recliner. If Karina and Houston shot him while standing over him like this, the travel of the bullets would not have been upward from his cheek into his brain. They would have been downward. What does that tell us? That instead, when Karina Cooper shot him, she was kneeling, sighting the weapon, like this. Ryan's here in the chair. She's like this. Most of her body is not exposed to the backspatter.
She shoots him in the face. The bullets travel upward into his brain from this angle. What spatter is she going to get on him? Her forehead, her face. The majority of her body is covered and concealed. What did Ken Martin tell you? Shot number 2. More backspatter than number 1. Because after shot number 1, a pool of blood forms. Shot number 2 is into that pool of blood on Ryan's face, an explosion of blood. Karina controls the scene. You saw the picture after she had the blood cleaned off from her. We had testimony that there was assistance in cleaning the blood off from her. That backspatter hits her face, and more importantly, it hits her hair. There's things you learn when you kill somebody. She's got a problem. She has blood on her face and in her hair. She can wipe her face. She can change her shirt before the police get there. It's going to look pretty suspicious if she takes a shower to clean her hair. Doesn't make any sense. She can't do that. So what does she do? What else could possibly explain what she's doing? She jumps on Ryan. She puts her face, forehead, hair into the blood coming from Ryan's face. Why is her face on the left side where the bullet holes are? Because she's concealing evidence. She's concealing evidence of backspatter that she received when she crouched down and shot Ryan Cooper in the face. There she is, after getting off Ryan Cooper. Why? Why would you sit on your dead husband who had just been shot and rub your face all over his face, directly over the wounds, soaking your face and hair with his blood? Because you shot him and you're covered in backspatter, which you did not anticipate. So you had to come up with a pretty quick plan. This was what she came up with. She's guilty, beyond a reasonable doubt. Another thing to consider. Yesterday, on the stand, Karina didn't have any trouble pushing back against things that she felt weren't true, correcting Mr. Kodiaga, or as defense said, trying to be accurate. Did you catch what she said yesterday during her testimony? Mr. Kodiaga, Ryan was sleeping when he was shot? Medical examiner never testified to that. Ken Martin didn't testify to that. Ken Martin said he was shot while he was in his recliner chair. That's how he put it. Nobody testified that Ryan was sleeping when he was shot. There's no testimony to that at all. Ryan was sleeping when he was shot? Karina says, yes. How does she know that? Wouldn't the answer be, I don't know? She said yes. Because she shot him. She's guilty of murder in the first degree, beyond a reasonable doubt. The science shows that she is. She's guilty because she shot him. She also aided and abetted in the murder with all the necessary requisite intent. The snaps established that. Her own statements establish that. The science establishes that. She's guilty. We're asking that you find her guilty. Thank you.
All right, ladies and gentlemen, that concludes closing arguments. What we're going to do now is I'm going to finish with the last few of the remaining jury instructions. So if you want to follow along, you can. We're going to pick up at number 27. Instruction number 27, nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. Instruction number 28, the duty of the jury is to determine if Karina Cooper is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Instruction number 29, during the trial, you've been allowed to take notes. You may take these with you to the jury room to use in your deliberations. Remember, these are notes and not evidence. Generally, they reflect the recollection or impressions of the evidence as viewed by the person taking them. It may be inaccurate or incomplete. Upon reaching a verdict, leave the notes in the jury room and they will be destroyed. Instruction number 30. Exhibits have been admitted into evidence and are to be considered along with all the other evidence to assist you in reaching your verdict. You are not to tamper with the exhibits or their contents, and each exhibit should be returned into court along with your verdict in the same condition as it was when received by you. Instruction number 31. You may not communicate about this case before reaching your verdict. This includes via cell phone and electronic media such as text messages, email, electronic messaging applications, and any other social media platform, including but not limited to Facebook, LinkedIn, YouTube, Twitter, TikTok, Instagram, Snapchat, and any other social media applications you may use. Do not do any research or make any investigation about this case on your own. Do not visit or view any place discussed in this case, and do not use internet or application-based maps or programs or any other application, program, or device to search for or view any place discussed in the testimony. Also, do not research any information about this case, the law, or the people involved, including the parties, the witnesses, the lawyers, or myself. This includes using the internet to research events or people referenced in the trial. This case will be tried on evidence presented in the courtroom. If you conduct independent research, you'll be relying on matters not presented in court. The parties have a right to have this case decided on the evidence they know about and that has been introduced here in court. If you do some research or investigation or experiment that we do not know about, then your verdict may be influenced by inaccurate, incomplete, or misleading information that has not been tested by the trial process, including the oath to tell the truth, and by cross-examination. All the parties are entitled to a fair trial rendered by an impartial jury, and you must conduct yourself so as to maintain the integrity of the trial process. If you decide a case based on information not presented in court, you will have denied the parties a fair trial in accordance with the rules of this state, and you will have done an injustice. It is very important that you abide by these rules. Failure to follow these instructions may result in the case having to be retried, and could result in you being held in contempt and punished. Instruction number 32. When you begin your deliberations, you should select a foreperson. He or she shall see that your deliberations are carried on in an orderly manner, that the issues are fully and freely discussed, and that every juror is given an opportunity to express his or her views. In order to return a verdict, each juror must agree to it. Your verdict must be unanimous. Where two or more alternative theories are presented, or where two or more facts would produce the same result, the law does not require each juror to agree as to which theory or facts leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based. It is your duty as jurors to consult with one another and reach an agreement, if you can do so without compromising your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with the other jurors. During your deliberations, do not hesitate to re-examine your view and change your opinion if convinced it is wrong. But do not change your opinion as to the weight or effect of the evidence just because it is the opinion of the other jurors or for the mere purpose of returning a verdict. Remember, you are not partisans or advocates. You are judges of the facts. Your sole duty is to find the truth and do justice. Occasionally, after a jury retires to the jury room, the members have questions. I have prepared the final instructions only after carefully considering the evidence presented in the case with the lawyers. I have tried to use language which is generally understandable. Usually, your questions about the instructions can be answered if you carefully reread them. If, however, you feel it necessary to ask a question about the instructions, you must do so in writing. I cannot communicate with you without first discussing your questions and the potential answer with the lawyers. The court attendant who works with you in this case from now on is in the same position as I am. She will take an oath not to communicate with you about your deliberations. She has not spoken to you during the trial except about mechanics of being a juror, and she will not speak to you when you have retired to deliberate, except to ask you if you have agreed upon a verdict and to manage the logistics of your service. Please do not place the court attendant on the spot by asking any questions about the instructions or the evidence. Jurors like to know how long each day they will deliberate and whether they will be sequestered. How long you deliberate any day between the hours of approximately 8:15 and 4:30 p.m. is up to you. You will not be sequestered. That is, you will be free to go home each evening if you deliberate more than one day. You will stay together during the day, including meals. Finally, if you need to notify anyone about the time you will be there, please notify the court attendant and we will make a phone available for you. Also, if you need confirmation of your attendance to keep peace with your employer, the clerk's office will provide you with the appropriate documents. All right, lastly, instruction number 33. Forms of verdict have been prepared for you and attached to these instructions. Your foreperson and each fellow juror will sign the form of verdict which accords with your findings. When you have agreed upon a verdict and the foreman or forewoman has signed the verdict form, please notify the court attendant. And that's it for the jury instructions. So, ladies and gentlemen, what you have then are just copies. Once you return to the jury room, we will get you the original. It has a little yellow tab with a verdict at the back. So that's the verdict that you would complete once you have reached a verdict. We will also, may take a few minutes, but we will assemble all of the exhibits and get those to you as well. I did discuss with counsel, we are not going to send the firearm that's been admitted into evidence back to the jury room. If the jury would like to view the firearm at some point during its deliberations, you would need to let the court attendant know, and we will make arrangements for you to do that. So just would need to let the court attendant know. All right. At this point, ladies and gentlemen, what we're going to do is I'm going to select two alternates at random by drawing. When I select those alternates, I'm going to refer to you by number, by seat, starting at 1 up at the top left, going across to 6, starting at 7, going across to 14, and then 15 and 16. Excuse me. Yeah, 15. All right. Oh, yeah, I'm right. 13 and 14 at the bottom. Sorry. Math has never been my strong suit. Once you've been excused, then the two people who are selected as alternates are excused. You're free to go. You're no longer subject to any admonition in this case that has been given previously. I would ask that you leave your telephone number with Ms. Davis. I will, once a verdict has come in, I will call the two alternates, let them know what the verdict was, and depending on what questions they may be able to answer some of those questions. So with that, Ms. Davis, over here. Sure, this will all go digital at some point, but so the first alternate is number 2. And the second alternate is number 10. So the two of you are free to go at this point. Leave your notes and we will destroy those as well. And again, if you want to leave your phone number with Ms. Davis, I'll give you a call once this matter has been finalized. Yep, you're free to go. Yep. Thank you very much for your service, and again, I'll talk to you later. All right, at this point, I need to administer an oath to Ms. Davis. Ms. Davis, please raise your right hand. Do you swear or affirm that you will not allow any communication to or from the jury during its deliberations, that you will not personally make any communication to the jurors without court order except to ask if they have agreed on a verdict, and not to communicate to any person the state of the jury's deliberations or the verdict agreed upon before it is rendered? Please answer, I do. All right. All right. With that, ladies and gentlemen, I will leave you to Ms. Davis and begin your deliberations.
Davis, when you're ready.
Mr. Thomas, please raise your right hand. Do you swear or affirm the testimony that you will give in the matter before the court should be the whole truth and nothing but the truth? You can put your hand down. Please state your true, correct, and legal name for the record.
Tyler Jarrell Thomas.
Are you at this time under the influence of any alcohol, drugs, or medication?
What's that?
Is there any medication that you normally take that you have not taken today? How old are you and how far have you gone in school?
36 years old. I graduated high school, attended some University of West Georgia College.
Where did you attend high school?
Here I was in high school.
Are you able to read, write, and understand the English language? Are you a United States citizen? Do you understand that you're charged with the following offenses in indictment 24 SC 005283, aggravated assault, riot in a penal institution, and possession of a dangerous weapon? Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial. Have you had enough time to speak with your lawyer, Mr. Slayton, about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney? Are you satisfied with his services?
Great guy, yes.
Attorney Slayton, do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
Yes, I do.
Mr. Thomas, do you remember having been arrested on these charges?
Fortunately, I do, yes, ma'am.
The state is unaware of any outstanding warrants related to this matter, Judge. Attorney Slayton, are you aware of any outstanding warrants related to this charge?
No, I am not. There is an issue that we spoke about earlier. There's a kind of a floating battery charge that has another case number that's in a pre-indictment status. I'm not sure if it's connected to this case or the prior case with Detrell Wimberly. But I'm not sure if that's real or not, but that's not, but no active warrants I'm aware of on this case, no.
Understood. And Judge, we will address Mr. Thomas's second case at the end of this plea colloquy.
Right. There's a case ending in 460. That's part of what you all have worked out?
Correct.
Okay, great. I'll make sure we cover it.
And so when you pull it up on Odyssey, there's three open cases. There's this one, the one that ends in 4460, and then there's another case that's in between those two, I believe, which is just a battery charge. And I'm not sure where that comes from.
Well, one, that would be a misdemeanor, so it would be in state court if it's going anywhere.
It was, what I saw, it was referred as an unlawful act in a penal institution, and I wasn't sure if it was upgraded into this case or the 4460 case.
Do you have the PI number for it? Because I can look at it while we're talking.
I do, Judge.
Okay.
It's 24 PI 005509.
All right. I'll take a look at that and see what I can find out about that.
Thank
Sure.
you, Judge. Mr. Thomas, has your attorney advised you the minimum and maximum sentence for each charge to which you're pleading to today?
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court? Do you understand the court is not required to accept the state's recommended sentence? Do you understand the court has the right to sentence you to the maximum possible sentence on each charge? Do you understand that there are multiple charges to which you are pleading to today, and the court has the right to run those charges consecutively or one after the other? Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts? Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice by your attorney or anyone else? Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which can carry a sentence from 1 to 15 years in prison? Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial? For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial. Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea? How do you plead to the charges in indictment 24 SC 005283 to count 1, aggravated assault, count 2, riot in a penal institution, count 3, possession of a dangerous weapon by an inmate?
Guilty, yes.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea? Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty? Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you? Judge, the state believes at trial we would show that on June 3rd, 2024 at 901 Rice Street in Atlanta, Georgia, which is in Fulton County, that the defendant was observed on a Vigilant camera footage removing a large club-like makeshift item from his pants and striking the victim, Mr. Manville Britton, repeatedly in a fight that took place in the jail. He was struck several times. The victim's jaw was swollen. He had a swollen eye. He sustained some injuries and was transported to Grady. This weapon is referred to as maybe like a makeshift kind of shaped type of a weapon. The state, in consideration of the resolution of this case, we are moving to dismiss 24 SC 004460. We are recommending to the court that he accept 15 months to serve. Of course, credited from the time that the offense occurred on June 3rd, 2024. We're not asking for any terms and conditions or probation because it's my understanding that the defendant will already be on a probated sentence. And so as opposed to having 2 probated sentences, he will already have probation in place. And so that is the terms for the court. And we have nothing further.
What's the sentencing range for a riot in penal institution?
Roman judge, I believe it's a year, but let me just check. I want to say it's a minimum year.
6.
My apologies, Judge. I had this on my other calendar with the minimums.
1 to 20.
I believe the minimum, so yeah, the 1.
Okay, so 1 to 20, and then the third count,
dangerous
the
weapon.
possession of a weapon by an inmate. 42-4. Oh, it's not even in this book.
I'm pulling it up on Lexus, Judge. Not less than 1 or more than 5 years, Judge.
Okay, but it's not has to be consecutive or,
It doesn't appear to be subsection B2 says any person who violates paragraph 1, which
Yeah.
is, yeah.
okay. So 1 to 5.
And my apologies, Judge. It's 1 to 20 for the aggravated assault. That's what.
Yep, that I knew. Mr. Slayton, do you know offhand how much probation Mr. Thomas has for his murder case? I know the charges were reduced, but
After speaking with him, I believe it was 10 years, and I believe he's on probation for 10 years, I believe.
do you have that case number?
I do, Judge.
Yay, what's that case number?
It's 14 SC 124579, and the 10 years is correct, Judge.
10 years probation?
Yes, Judge.
Got it. Okay. All right. I just wanted to confirm, I wasn't doubting you that there was probation in that case, but if it's for 1 year, I might have a little more in this case, but 10 years is ample. Okay. What do you want to add, Mr. Slayton?
Nothing really. I mean, I would ask that you would accept this, and I'm excited for my client to, come to the end of this 10-year sentence and look forward to building a life outside of incarceration. I have full faith that he will do that. And I've enjoyed, speaking with him and getting to know, how he's going to move forward after his time in the corrections facility.
How is he going to move forward?
I think as initially he's going to be, looking for employment, but really honestly, just getting to be with his family. I think that's the main thing right now.
Okay. All right. Mr. Thomas, any questions about any of this or anything you want to add?
No, sir.
Okay. Well, you've already told me how you're going to move forward. I was just curious what you told Mr. Slayton, see how they lined up. You've got family and friend support here as usual. I find there's a factual basis for your plea. We actually all got to watch the video. And I understand your perspective that it was almost a preemptive strike because you were concerned if you didn't do this, something would happen to you. But the video shows what the video shows. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about, and no one is forcing you to enter this plea, but you've decided this is an okay way to work this out. Is that a fair statement? Okay. All right. Then I'll accept your plea. We don't have to talk about probation. Mr. Slayton, can someone in my office electronically sign your name to this indictment? Ms. Davis?
Yes, Your Honor.
And Mr. Thomas, can we electronically sign your name? Of course. You ever been to Mount Zion?
Mount Zion?
Yeah.
What do you mean by that? Is it church?
No, I didn't realize it was its own little town. It's right next to Carrollton.
Mount Zion, yeah.
Yeah, I spent all weekend last weekend in Mount Zion at Mount Zion High School. My kid was playing in a baseball tournament. It's far from Atlanta, but it is near to home for you.
It's a very rural town. So
It is. It's a very nice high school. They have put up a good school there. The baseball field football field is nice.
from my experience, I really want to deal with the youth and try to give to the community and tell my situation and my story. It's been a burden to my family. It's been an embarrassment to my family. So if I can talk to the youth and give them the ins and outs, so let them know how the system and how hanging around with
The wrong people.
Yes, sir.
Yeah, well, you could start at Mount Zion High School. It's a good place. There'll be a lot of youth there.
Wherever God call me, I'm gonna be there. It's all good.
Okay. That was my first trip to Carrollton, and the suburb of Mount Zion. I got some good news for you, Mr. Thomas. The unindicted charge flows from a state court criminal case that has been dismissed. It was then transferred to the district attorney's office, and it is the same conduct that's in 4460. So the PI can't really go anywhere. I mean, the system should have swept it up. It didn't because it just said battery, but it's Derek Wimberly, same date. And maybe because the Wimberly indictment had a whole bunch of defendants, that didn't clear out the PI. But that's not anything that will ought to come back to haunt Mr. Thomas. If it does pop up, I'm making it very clear on the record, the state's motion to null pros 24 SC 004460 effectively extinguishes 24 PI 005509. They are one and the same. So that just leaves your sentence, which is a 15-month sentence. You will get credit from the day of the incident, which is June 3rd of 2024. So that carries it through September of 2020.
Defense's motion to extend previously ordered deadlines for witnesses, exhibits, and pretrial motions in completing discovery. Part of the reason I believe we need to have a hearing on these matters as well, and I'll let you make your argument in just a moment, Mr. Zellman. Have you discussed with your client specifically as it relates to the raw data that you are seeking, specifically for Charles Adelson and herself, that this has the potential to reopening the door of the conflict?
Your Honor, I don't think that it would. It's in the same category as the emails that Your Honor authorized us to obtain in April, the raw, unredacted, unfiltered emails from our client's own account.
While they are certainly discoverable, and while you have an interest in using them to prepare for, the question remains, have you discussed with your client the possibility of this reopening the door to any conflicts?
No, we have not, because I don't think that it would reopen the door.
Very well. You may make your argument.
So, Your Honor, you may recall a number of times we've been before the court, and the defense, and as laid out in the motion to compel, we have been asking for the raw, unredacted downloads, the emails, and we were repeatedly told that that had been provided to us. When we were able to retain an independent forensic data expert and provided them with the materials that we had been provided, we were informed that those are not the raw forensic extractions. And I was asked to obtain the raw forensic extractions. And in the motion to compel, I actually cut and paste the expert's explanation. I'm not going to try to paraphrase it. It's an explanation that he provided as to why it is his recommendation that we obtain the raw forensic extractions. That's what I did. I've requested that. It's taken, we're now at a month since I made that further request, and I believe that we're entitled to that. I think the rule provides that, and our intent, in part, is to verify the cell brights that the state has prepared. The only way to do that, according to our expert, is to obtain the raw extractions from the state. And that's why we're asking for that, Your Honor.
Ms. Kappelman, you may respond.
No objection, Your Honor. I would just ask that whatever reports are generated by their expert as a result of that data being re-cell-brighted be provided to my office in a timely manner, because I'm advised, based on the version of the program and the type of program they use to produce a report to verify our report, there could be some small differences involved. So I would like to not be surprised with that at trial.
Well, as to that, I will grant the defense's motion to compel. As to the issue of the conflict, specifically, Mr. Zellman, in part, when we had the first case management, I had counsel verify that they had no conflict as far as giving conflict-free representation to Mrs. Adelson. Should anything change with your review of these Cellbrites that may include communications from prior counsel or deal with matters that pertain to information that was provided by Charles Adelson, at that point, we are going to have to revisit the issue. Does everyone understand those?
Yes, sir. May I approach with a proposed order?
You may.
Okay.
Thank you.
And Your Honor, just to advise the court, Mr. Corbett and the defense expert have been communicating over the last 18 hours or so that once that order was signed, Sergeant Corbett was going to upload that to a portal that they've already tested this morning, so that our expert can download it. That'll be the fastest way for them to do that. He said as soon as, Sergeant Corbett indicated that as soon as he was given instructions to start the process, he would do so.
Right. As to the second motion, the extending of all deadlines for the defense. In particular, we've already had 2 extensions that have been provided by the court, first from the April 30th deadline, second from the May deadline. Does the defense have any motions that are unrelated to the new discovery?
No, Your Honor.
All right. As to the motions that you believe you still need to file that are in some way related to this discovery, what is preventing these motions from being filed and you seeking leave to amend as necessary?
Your Honor, due to scheduling, we were only able to depose Mr. Newland and Sergeant Corbett Wednesday, Thursday. We are deposing Special Agent Pat Sanford, I believe, on this coming Tuesday. Before filing those motions, I think it's appropriate to make sure that there's a good faith basis to do so. And having those depositions, that testimony, in my opinion, is necessary before we can do that.
Right. And I believe there are some other depositions that are scheduled for July, or I believe next week as well.
Yes, sir, we have them on Monday as well, and maybe Tuesday and Thursday.
Part of the reason that we have, whether it be discovery or any sort of deadline cutoffs in any case, is not simply arbitrary of the judge just saying, get it done by a certain date. It is so we can proceed orderly to trial. I believe your proposed dates were to within 4 weeks of when you believe the state has fulfilled its obligation, that's when you would want to file your motions.
Well, Your Honor, given that we filed these on June 27th, we're obviously 2 weeks past that.
Oh, yes, we are.
And it's certainly not our intent to do anything to delay the commencement of the trial as scheduled.
The proposed date of when this would occur is not specific. It's not certain. It's pretty much a moving piece of jello. Is there anything that you can do to convince me that it's otherwise going to be a specific date in what you're asking to do with filing these motions several weeks after you believe the state has complied?
Unfortunately, it has been a moving target because we have not received all of the discovery from the state. During the depositions, during yesterday's deposition, we learned that he had conducted call frequency analysis between Donna Adelson and Charlie Adelson for a longer period of time than that had been previously disclosed. He is going to send us that if he had completed a report. He's also sending us the PDFs of the actual call frequency analysis that is contained in the demonstrative, because those are just excerpts of the call frequency analysis. So he's going to be sending us the completed call frequency analysis. So I say that to demonstrate that it is difficult for the defense to file any appropriate motions or to provide appropriate responsive either demonstratives or exhibits when we still have not received everything from the state.
At the same time, to file, and how many motions are we talking about at this point?
Potentially 3, Your Honor.
As to these 3 motions, would any of them affect the ability to actually move forward with the trial on August 19th?
No, I don't believe so. None of them are just positive.
Very well. Do you have any further argument in support of your motion?
No, Your Honor.
Ms. Kappelman.
No objection, Your Honor. We've just asked that we be given the same grace. I'm aware of at least 1 or 2 more things that the state intends to do that could, need to be done past the deadline. So all indications are that both sides are working diligently to get this done. I understand your comment about the Jell-O, and I've got a couple orders myself of Jell-O that I'm wrangling, so I'm trying to minimize it, but things do come up past the deadline, so we're going to have to work
Ms.
through those
Kappelman
things.
specifically asked these emails, which has contributed to this. What is it else that you believe is going to come up on the state's behalf?
The emails?
I said, other than the emails,
Oh,
what do you
do I
think is going
think's
to come
gonna
up on the
There's
state's
a
behalf?
defense witness that's been listed that the state has discussed trying to depose and may try to get that done before the deadline. There's a handwriting expert that the defense is aware of, that a handwriting expert exists, but they haven't been given the name or the report yet. I don't have the report yet, so that's something that's pending that would be in violation of Your Honor's order. So there are a couple outstanding issues that I'm aware of. I was not aware of the issue that the defense just brought up regarding Corbett having done a report, but he does do work to generate the slides that were prepared and discovered by the discovery deadline. When asked about how did you come to those conclusions in deposition, he's going to say, I looked at the data. Well, they want to see that data. Okay, we don't object to that, but I don't think that's the same thing as a discovery violation.
The final pretrial hearing is August 8th. As to the date of when all motions need to be filed, so we can have a meaningful hearing on August 8th and proceed to an orderly trial on the merits. These motions are going to need to be filed by July 21st. Any motion that is not filed by either the state or the defense by that date, the issues are subject to being deemed as waived. If you need to seek leave to amend as to the specific motions that will be filed on this date, you may certainly do so. However, again, this is not just arbitrary date making to throw something out. If we are going to in fact have a trial on the merits that will be orderly, both parties needed to see what you intend to raise as pretrial legal issues that the court needs to rule upon. There's not going to be a trial by surprise either for the state or for the defense. Am I making myself clear?
Yes, Your Honor.
Yes, Your Honor.
Will you state those dates one more time? Motions to be filed by July 21st and final motion hearings on August 8th. Is that correct?
The final pretrial hearing is on August 8th. This time has already been set apart by a previous order. As to the motions in limine that have been filed, I believe the defense has renewed its motion concerning the Latin Kings. Is that correct?
Yes, Your Honor.
Has the state filed any motion in limine by the previous deadline?
We renewed motions that were filed previously. There's nothing new.
Well, as previously ordered, copies of all of these motions, when they are filed, they need to be served upon the court. Please do so if you've not already done that regarding what has already been filed. I believe the next date that we will have, unless there are other issues that need to be addressed, will be August 8th. Does either party have anything it needs to raise?
Nothing from the state, Your Honor.
Can I have a moment, Your Honor?
Go ahead.
Nothing at this time, Your Honor.
Well, we are in recess for this afternoon.
Thank you, Your Honor.
You can, yeah, go ahead. What's that? It's good to file as is.
Did you enjoy your holiday, Judge?
The weather was good in both Maine and Canada. Could have been cooler, but it was nice.
What's going on at GDC. And we're going to get you sent back to GDC just as soon as I can make that happen. Mr. Slayton, anything else on behalf of Mr. Thomas?
Nothing for me, Your Honor.
Ms. Davis, anything else on behalf of the state?
No, Your Honor.
Questions, concerns, Mr. Thomas? All right. Keep your head down before you get back to GDC. Pardon me? He doesn't have probation. 15 months, 1 year and 3-month sentence.
All right, Judge, I will see you on Monday.
Oh, I see the connection with Mr. Wolf. Mr. Wolf represented Ricardo.
Perhaps have a last name.
Well, Ricardo Thomas, the co-defendant in the murder trial. As I try to figure out how you got roped in with Mr. Wolf and this and that, and the family knows Mr. Wolf because he represented Ricardo.
They do, but actually, Suzanne Tevin said an offer to get on this case, and she ended up sending it my way.
Oh, all right.
Just trying to get as much as I can, but yeah, they do know Mr. Wolf, and I've been really lucky to be in his office. I've learned a lot.
Good.
But thank you.
You're welcome. Oh, yeah, I'm sorry. I didn't do, I was like, "Oop, there's this number." Yes, ma'am. It is 1 year and 3 months. Counts 1, 2, and 3 run concurrently. Felony confinement only. All right, Ms. Simpson, and Ms. Harvey, thank you for hopping back on. But we're good to go. What? This Zoom will stay open or to get on Michelle's? Okay, so Ms. Harvey, we are reconvening at 1 o'clock for one more plea in that case you just heard all about, the icky motel room beating death. There's another guy who's he's the one who I think was just the guy working at the motel. So he's gonna plead at 1 if you don't mind rejoining us then.
I will. Thank you, Judge.
Okay, and Ms. Simpson says, hey. All right, but that's a different Zoom, so I'm shutting this Zoom down. Another Zoom.
Sent me the link already, so we're good to go.
Good. All right, I'll see you guys. That'll be Zoom number 3 for me today at 1 o'clock. Thank you.
Thank you, Judge.
Bye-bye.
Still going out on your 2 or down to 1?
Well, I think it's 3 now.
He has a 3.
The one defendant has 2.
Shadows allegedly followed his every step through social media and GPS. When they caught him slipping, they let loose. At least 31 shots tore through his car. That wasn't no shootout. That was an execution. Surveillance footage later showed it all. 3 shooters creeping across the parking lot, rifles locked in, ready to squeeze. Fulio was sitting in the front passenger seat. He ain't even get a chance to run.
Look at this video. This is at the hotel, and you can see the shooters are getting in position for their planned out murder. And they are shooting at Charles now, and you can see that he's the passenger in that car that's moving and trying to flee. And again, they're still shooting at him. He's the right front passenger in that vehicle.
These dudes weren't stupid. Nah, they were calculated. They had been watching Fulio real close. They knew where he was headed, had the whole night mapped out. One of them, word is he was cool with Fulio's ex, and the other, a young girl named Alicia Andrews, pregnant at the time, was allegedly tailing Fulio all night. She followed him from club to club, moving like a spotter in some military mission, sending text after text to her people, dropping his exact location. Thing is, they weren't even seasoned street vets. Most of them barely out of high school, just kids caught up in grown man beef.
Guys, one girl. The girl's pregnant currently.
No.
Which makes it even crazier. One of the guys, when they were arresting him, I guess he had a gun to his head. Did you hear this whole story?
Yeah, they said he was suicidal, and he started talking about he wanted to bring a Bible with him or something.
This crew, they range from just 18 to 30 years old, but they're being accused of pulling off one of the biggest rap murders we've seen in a minute. And now, the trial's going down right now. Some of them staring down the death penalty, and trust, the state ain't playing with them. Prosecutors already said it. They seriously considering taking it all the way. Lethal injection, no mercy.
These are all signs that things are gonna go very bad for them. Like, you got a girl in it, she's pregnant, he's suicidal, wants a Bible. It's not going good.
Not going good for who?
For the killer.
Now here's where it gets even darker. One of the main dudes, Rashad Murphy, he wildin', fired his own lawyer. Yeah, this man is facing a first-degree murder charge that could end with a needle in his arm. And he told the court, I got this. They warned him, judge, lawyer, everybody told him not to do it. But Rashad wasn't trying to hear it. He filed for a speedy trial and straight up asked to rep himself. On top of that, he wrote up these handwritten letters to the judge saying they treating him like he's already guilty. Said he couldn't make no phone calls, couldn't send no letters, couldn't even get access to his legal papers to prep for his own defense. He was begging the court just to let him see his documents. Some folks think it's a strategy. Others, they say he's already cracking under pressure, folding under the weight of what he's accused of doing. And honestly, the evidence stacked up against him is looking real heavy.
It's not like they're going to get off for this.
No, they got so much evidence against them. Like, when you go through it, you can pretty much just, all right, pick a prison. Where do y'all want to go? It's not, you can't even come up with a defense for them.
Investigators weren't playing either. They came with receipts. They got Ring camera footage showing the suspects loading up rifles into duffel bags, moving like they was going on a mission. They pulled GPS data from the suspects' phones, tracking every move Fulio made that night, every stop, every turn. They even uncovered text messages between the crew, talking about the hit before it even went down. And the shell casings they found at the scene, they matched the guns that were sitting right in the suspects' homes. It's looking airtight.
Bullets. They found bullets in that kid's house. They found one of the murder weapons. They found bullets matching from the shooting scene. This kid kept collectibles from the case. Like, mad inside of his house.
As prosecutors started laying all this out in court, that pressure, it finally broke somebody. One of the defendants, sitting just feet away from Fulio's grieving mama, collapsed. Now, the cameras ain't catch it, but folks inside the courtroom said dude fell clean out his chair. He was shaking, gasping, mumbling, "I can't breathe." Was it fear? Was it guilt? Or was it that moment when it finally hit him? He might spend the rest of his life in a cold concrete box. Nobody knows for sure, but what is clear? The wall's closing in fast. Let's stop right here for a second, because this ain't just about gang retaliation or rap beef gone sideways. This right here, this about how the internet done turned real-life death into digital content, where disrespecting dead ops is just another way to boost streams, where moms out here scrolling YouTube only to find songs making fun of their child's murder. Fulio did it to others, and in the end, the others did it to him. This cycle, it's deadly, and now it's cost 6 people everything. 1 man dead, 5 more facing life, and one of them, she pregnant. That baby might grow up only seeing their mama through glass. And we're not done. The evidence trail, it's even uglier than anybody expected. Turns out one of the suspects might have accidentally exposed all of them, just for a little bit of social media clout. So how did we even get here? Prosecutors say this wasn't no heat of the moment thing. This was a coordinated, calculated hit. They say this started long before anybody pulled up in Tampa. We talking surveillance, group chats, out-of-town travel, multiple whips, and big rifles. This was planned like a mission, and it all started at home. Footage shows Rashad Murphy, Davian Murphy, and Sean Gathright packing up bags big enough to stash full-blown rifles, right in a regular neighborhood. What was in those bags? At least 2 military-style assault weapons. Where was this caught? Not from a snitch, not from the feds, their own surveillance camera.
Have evidence of the defendant's co-defendants very clearly meeting at Sean Gathwright's house on his video camera, where they are loading up big bags that are definitely big enough to hold these assault rifles that were used in this case.
One of the most disturbing parts, Fulio's final hours, were basically live streamed by the man himself. He was on Instagram, posting clips from his birthday turn-up, showing where he was, who he was with, what he was doing, all while the people plotting on him were watching every move. Investigators say Alicia Andrews and Isaiah Chance, folks who were pretending to be cool with him, were really acting as lookouts. From the club, to the after party, to that hotel lot where it all ended. They was tracking him the whole time, acting friendly while setting him up.
Jones was in town celebrating his birthday and posted on his social media his locations several times throughout that night. Surveillance video was critical in this investigation, as suspects were seen on video following Jones from location to location.
The shooters didn't just roll up and start dumping. Nah, they parked across the street and waited. Watched. They were patient, moving like they had done this before. Then at 4:38 a.m., 3 of them slid out the car and crept toward the Home 2 suites. They were strapped, 1 with a handgun, 2 with rifles, locked in and ready. Then they let it rip. 31 shots tore through Fulio's SUV. It was a straight ambush. No warning, no mercy. 3 other people were in that ride too. They got hit, but somehow by the grace of God, they survived.
This barrage of gunfire also struck 3 additional victims who miraculously survived this incident. It's clear from that video what they were set out to do and what they had planned to do.
But why though? What could make 5 young people, including a pregnant woman, plan and carry out an execution-style hit in the middle of a public street? According to prosecutors and police, it all comes down to that same cycle: street revenge. They say one of the shooters had a brother, went by the name Spaz, who got killed by someone tied to Fulio's camp. And from there, it was on site. That loss lit the fuse, and they wanted blood back.
I think he had nothing to do with the murder though.
No, I mean, it's actually pretty ugly what happened, because one of the suspects, their brother, Spaz, was allegedly killed by one of Fulio's friends.
Yeah.
Fulio rapped about him, and I believe there's a video of him urinating on his grave.
There's multiple videos of Fulio dissing this.
I mean, I don't think Fio personally pulled the trigger on Spaz or anything. But the truth, this whole thing got ugly. See, one of the suspects had a brother named Spaz, and word is someone from Fulio's crew was the one who took him out. And Fio? Man, he didn't just rap about it, he mocked it. He put it in music videos. There's even a clip where someone, allegedly Fio or his people, is seen pissing on Spaz's grave. That ain't music. That's a declaration of war. So these 5, they didn't just roll out to Tampa to drop a diss track. They came with guns, bullets, burner phones, and a whole blueprint. But here's the twist. They wasn't slick about it. Matter of fact, they basically wrapped the evidence up with a bow and handed it to the police. Let's run it down. Alicia Andrews' phone was pinged from Jacksonville all the way to Tampa. hitting every location Theo touched that night. License plate readers caught the exact cars used in the ambush. Hotel surveillance cameras caught the crew moving in and out, right before and right after the hit. Forensics matched the shell casings from the crime scene to rifles they found in Rashad Murphy's house. One of these dudes even kept souvenirs, bullet fragments and shell casings, just sitting in his home like trophies. And if that wasn't enough, the text messages they found, some of them were straight up celebrating. One of them literally said, "I'm coming home. My thirst is finally quenched." That ain't just a message. That's a confession.
They were caught on license plate cameras. He used his mama's car. His mama said, "I had that car that my son had."
That's how bold they were with it. Rashad Murphy, especially, dude really thought he could outsmart the whole system. He tried to play slick, left his phone at home, but used everybody else's. Like the feds wasn't gonna piece that together. Then, he made the wildest move yet. He told the court he wanted to represent himself. Even his own lawyer looked at the judge like, "Yo, this is straight madness." But Murphy stood on it. He said the jail conditions were so bad he couldn't even prep for his defense properly. And just when you thought that was the end of it, he pulled out another card, the insanity defense. Back in November, he told the court he was going that route. But here's the thing. Legally, that don't even make sense. You can't plead insanity when the evidence shows you spent days planning a hit, moving like a tactician, packing rifles, coordinating travel, sending play-by-play texts. That's not crazy. That's cold and calculated. That's the exact opposite of insane.
This guy's nuts. I think that's why. I mean, he wants to defend himself, which is insane in a death penalty case. And then he actually has said that he may use an insanity defense, which also is insane in itself when the facts show otherwise, that these guys had meticulous planning and attempts to cover up the crime. And when you have that, good luck in getting an insanity defense, because to sustain an insanity defense, you have to have an established medical condition, and you have to not know the difference between right and wrong. But when you meticulously plan and then try to cover up your tracks, that shows you knew the difference between right and wrong. It shows you knew what you did was illegal. And when you want to just try to put forward an insanity defense as your own lawyer, it doubles the level of difficulty.
So yeah, Murphy's whole defense, it might already be dead before it even gets moving. And if he keeps pushing to act as his own lawyer, he might end up incriminating his co-defendants in open court live. That's got folks around the other suspects seriously panicking, especially Alicia Andrews. See, she's the only one who didn't waive her right to a speedy trial. And legal analysts, they think she might be cooperating with the prosecutors. And honestly, it would make sense. She's young, she's pregnant. She might just want to see her baby grow up outside the walls. If she flips, those dominoes could start falling real fast. But don't get it twisted. This story ain't over yet. Inside their jailhouse meltdown, when prosecutors laid all their cards out on the table, it was obvious somebody talked, and the whispers, they all pointed in one direction: Alicia Andrews. Andrews was just 21, pregnant at the time of the murder, and facing the same first-degree murder charges as the dudes who actually pulled the trigger. But here's what made folks start connecting dots. While the others stalled and delayed, she did the exact opposite. She asked for a speedy trial. Now in the courtroom game, that ain't just a bold move, that's a message. To the DA, to the judge, to the other defendants, I'm not waiting. I'm not taking the fall. Legal experts been saying it since day one. That move right there could be a warning shot or a quiet signal that she's cooperating.
And they just recently did it where the girl isn't waiving her right to a speedy trial, and they believe she's going to cooperate.
Right. Actually, one of my members, Kilcon RL, mentioned that. He said Alicia Andrews, who's the girl who's pregnant, she asked for a speedy trial, but the other three waived that. So yeah, I guess that means she's cooperating now.
But what really sealed it wasn't just the paperwork. It was what came next. Alicia Andrews sat down and gave a full interview to police right after her arrest. No lawyer, no stalling. She started talking. She admitted to being there, and she walked detectives through their entire trail across Tampa. Every move, every stop. Now, she ain't say who pulled the trigger, but honestly, she didn't have to. She gave up enough details to put the whole crew exactly where prosecutors needed them. That interview might have just handed the state the blueprint to build this entire case.
Alicia, the girl, she gave an interview with police right when she got picked up. So she's already spoke to them and confirmed, oh yeah, we were here.
After that, investigators went straight to her phone, pulled the GPS history, and it told the whole story. They tracked the crew's path from club to club, from the B&B to the hotel. Alicia might not have pulled pulled the trigger, but she played the role of a modern-day recon scout, helping the killers follow their target both digitally and physically. It was like something out of a military op. Except this mission, it was reckless, it was senseless, and it left a man dead. But prosecutors ain't stopping at Alicia. In a move that's got defense attorneys shook, the court just approved something major. Prior gang-related killings can now be used as evidence, not just background noise, but to show clear motive in this case. That changes everything.
I do find, generally speaking, that this is evidence that does help create motive and intent and explain the crimes charged.
See, the court didn't just look at this like one isolated hit. Julio Fulio's murder wasn't random. It was the climax of a long brewing war between some of Jacksonville's most dangerous rap crews, 6 Block, ATK, and 1200. And this wasn't no rap battle type beef. This was body for body, real street wars, where every diss track, every grave insult, every IG live came with consequences. Disrespect got paid back in blood. Andrew's boyfriend, he was allegedly tied to one of them rival cliques, and one of the shooters, he had a brother who got killed in the same feud. That brother's grave, desecrated in one of Fulio's music videos. Yeah, that kind of violation. And the judge didn't throw any of it out. They allowed all of it into the record. The gang ties, the prior murders, the disses, the grave disrespect. Because this ain't just about one night in Tampa. This is about a war that's been brewing for years.
This is something in Jacksonville that is very well known. These videos, both by our victim as well as by the rival gangs, are posted immediately. It's in the public domain, and it details this long-standing feud.
Even worse, some of the shooters gave themselves up without even knowing it. Let's talk about Rashad Murphy. You already know about his wild moves, trying to fire his lawyer, claim insanity, and rep himself in a death penalty case. But what really shocked prosecutors was what Rashad left behind. Surveillance cams from his own house caught him, and the others packing up bags big enough to stash the same type of rifles used in the hit. And it gets worse. Rashad was slick enough to leave his phone at home, but he used other people's phones instead. The state subpoenaed those phones and traced them all through Tampa. One of the killers even paid for stuff using a cash app card, and police tracked it all down with purchase history and IP data. And Rashad, he was riding in his mom's car, caught on camera. When they asked her about it, she said, "Yeah, my son had it. That was game over." But the coldest part? After the hit, one of them texted, "I'm coming home. My thirst is finally quenched."
That's the same guy who, after the murder, allegedly sent out a text, "I'm coming home. My thirst is finally quenched." Like, it was a mission for him. So, I mean, if we're talking about motive, that's classic get back, right? Hey, his people did something to my brother. They kept laughing about it. They've desecrated his gravesite. This is a rapper who's been known to make videos at gravesite or laugh at the dead. Now we get to laugh at it.
A declaration, a celebration, a confession. This whole tragedy wasn't just about 5 reckless people. It was about a culture that turned funerals into marketing and death into content. Fulio was part of it too. He mocked dead ops, filmed at their graves, and in doing so, he lit a fuse that ended with his own name on a toe tag. The shooters? Just kids. One of them only 18, with a trail of alleged shootings dating back to age 17. What happened in 5 years that turned a boy on Twitch into a boy with a gun? Cops. They never stood a chance. The real tragedy? How preventable it all was. Social media became the new street corner, where threats come in captions and retaliation gets measured in likes and shares. Now Florida law enforcement is on edge. They believe this war ain't over. There's still people out there. People with guns, with grudges, and now with martyrs. But the state? They're drawing the line right here. They want this case to send the message, from rap beef to life sentences. So what does it look like when a man watches his whole future disappear? When Hillsborough County brought those defendants into court one by one, reporters said it was like nothing they'd seen in years. This wasn't just a legal case, it was a reckoning. Sean Gathright, just 18, got told he'd spend the rest of his life behind bars. At first, he didn't flinch, but then they laid it out. Surveillance footage, firearm forensics, texts, cash app receipts, every piece of evidence stacked around him like a wall. Witnesses said he slumped forward, eyes locked on the floor, mouthing the same words over and over. "I ain't kill him. I ain't kill him." But in Florida, if you help plan a murder, even if you never touch the gun, you're just as guilty. And Sean, he wasn't just involved. He was caught on video prepping for the ambush. But it was Rashad Murphy who stole the show, for all the wrong reasons. Court started. Rashad stood up and fired his lawyer, again, despite every warning, judge, lawyer, even the prosecutor, telling him it was a catastrophic mistake. Rashad insisted on representing himself. It was like watching someone try to do surgery on themselves with a butter knife, live in court. He blamed jail conditions, said he couldn't send mail, couldn't call his lawyer, couldn't even prep his case. In a handwritten letter, he told the judge he was being treated like he was already guilty, but the courtroom wasn't buying it. To go to trial in Florida, especially in a death penalty case, you gotta be found mentally competent. And Rashad, he wasn't helping himself. He had already hinted at an insanity defense, even though prosecutors say he helped carry out one of the most calculated murders they'd ever seen. That contradiction alone killed any chance at leniency. Then came the collapse. As Rashad stood alone trying to cross-examine his own fate, he froze. His knees buckled. He dropped right to the floor. One bailiff rushed in. Another called a medic. His mama screamed from the gallery. The judge called a recess. No cameras caught it, but witnesses say Rashad broke down completely, trembling, sobbing, as the weight of that life sentence crushed him in real time. And while all that was going down, Fulio's mama sat in the front row, silent. She had watched people disrespect her son, blame him, dissect him, even say he brought it on himself. But later she told reporters he was still my son and he didn't deserve to die on his birthday. She'd seen the videos, she'd read the comments. But in that courtroom, all she had left to hold on to was the court's justice.
Let's not lose sight of the fact that there are innocent victims in every homicide case, the loved ones who are left behind. His fans knew him as Julio Fulio. But to his mom, he's Charles. We're fighting to make sure that she gets justice.
But even justice felt cold, because what nobody talks about, what don't trend on Twitter, what don't go viral on TikTok, is what happens after the shooting stops, after the sentencing, when mothers go home alone, replaying that surveillance video in their head over and over, when a child grows up visiting their mama through a thick glass window, all because she followed a man who chased fame by chasing bodies. In this case, it's the perfect tragedy of our time. Clout killed Fulio, loyalty buried the suspects, and TikTok turned it into entertainment. But there's one more chilling layer. Investigators now believe Youngin Ace, Fulio's biggest rap rival, might have known about the hit in real time. And in a twist nobody saw coming, DJ Academics revealed that police were kicking down doors, executing arrest raids at the same exact time he was live, interviewing Youngin Ace.
The moment Youngin Ace was sitting with me for the interview, the cops were raiding the guys. The exact moment. Everybody who got locked up for the murder, the 3 simultaneous arrests, happened exactly when he's talking to me. And I think, I don't know what his perspective is now, but his perspective is then, and maybe he just doesn't know it. He was like, hey, no, don't come with it.
Whether Ace knew anything for sure is still unclear, but the symbolism? Yeah, nobody missed that, and neither did they miss what he was sipping on. A bottle of Don Julio sat right there on the table beside him, his drink of choice. Intentional or just a cold coincidence, the message hit hard. Don Julio, Fulio, toasted online. Now all we can do is wait. The trials are still moving. Alicia Andrews is expected to be the first to face a jury this year. Rashad Murphy's solo act might end in disaster or a last-minute plea deal. And the gang war that sparked all this? Yeah, it's still breathing. Cops are already on edge, bracing for retaliation. As one sheriff said, it ain't over.
Unfortunately, I think young people think this is a game. And there'll be comments about this in the statement that I make, and they make it like it's a video game. It's not. This is real life. So he has a mother, he has parents, siblings, probably friends, and they have to deal with these kind of losses, and it's unfortunate. Now the next thing is these groups. I won't name them. They know who they are. We're not going to tolerate any retribution, any revenge. We're going to watch. We're going to be around, paying attention to what's going on. But it's unfortunate. It should never happen to our kids. And I've never seen so much devaluing of human life. It's like it's fun, and they talk about it in rap videos and songs, and it's just doesn't make any sense.
This case, it was never really about rap. It was about power, revenge, ego, and who gets the last post. Yeah, the courtroom spoke. But in a world where music videos feel like murder diaries and funerals get live streamed for clicks, who's really listening? If you felt this, go ahead and tap the next video on your screen. We got more just like this. Real stories, real truth.
You are as guilty as they are because you were an essential part of that crime. When you went to spend that blood money on sneakers and jerseys, you revealed to the court the value you place.
So, well, there isn't anything for us to really watch. I know we are on verdict watch for Miss Karina. Let's see if Law and Crime actually got the verdict clock up. Law and Crime might have a verdict clock up. Oh. Nope, they just showing a regular clock, regular feed. They don't got the verdict clock up, so we don't know how long it's going to be, y'all. We've watched. Who else did we watch today? We watched a little Julio Fulio clip. We've watched Judge McBurney's courtroom, and we've also seen Donna Adelson have her little motion here. So we watched quite a bit. It's 2:00. It's on a Friday, so we might as well have us a good time and check on out. Now, if Karina gets a conviction today, if she, because we know she's gonna be found guilty. But if it comes down today, I might jump on TikTok and have a conversation with the people. So if you're not following me over there, you can follow me on TikTok. I don't post content on TikTok like that no more. They only get in law school and TikTok shop over there. They only get what pay the bills over there. I ain't doing nothing else over there. Other than that, that's what I need to work on for y'all. I need to get the Faith Evans lawsuit. Y'all know Faith Evans is being sued by Biggie's estate. I was supposed to work on that, but I didn't. So I'm gonna probably try and work on it this afternoon, this evening, while I'm doing nothing. I'm about to go ahead and prep for dinner at 2:00 because I'm not ordering nothing. I mean, I ordered, y'all. I spent $700 in groceries today. $700 worth of groceries. And when I say $700 worth of groceries, and when I say we ain't ordering a thing, ain't nobody eating nothing fast. The fast food they're gonna be eating is something that came out the air fryer. Okay, I'm not buying nothing, so I need to go get dinner ready for this week, for this evening, and I might take them back to the pool. We might go back to the pool today. But all right, y'all. I want y'all to have a good, safe, and happy weekend. I shall see y'all on Monday. My girl 21, she been trying to drink and baby a mess. She won't go out nor hang out. It have to be with me and my sisters. Hey, I don't blame them because the streets is wicked and wild out there. Yeah, I mean, it's six people up in here. There's 6 folks in here. Everybody got to eat. When I say we got food in the house, we got food in the house. We got food, fruit. I'm going back on my diet next week. I did buy some workout equipment from Amazon for Amazon Prime. I said I need to get my little workout on because I stopped. I fell off the wagon, but I'm about to get back on. I had to give me some protein, little protein shake. Had to give me some fish and some turkey. So I'm back on it. I'm back on the wheel. But all right, D Wood and everybody else in the chat. Hope y'all have a wonderful weekend. Be safe, and I shall see y'all Monday.